ಹಲೋ ಸರ್, ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್? ಹಲೋ
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಹಲೋ,
ಕೇಳಿಸ್ತಾ ಇದೆ.
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್, ಕೇಳಿಸ್ತಿದೆ.
Lordship's kind permission, my lord.
Huh? Is there any interim order? What is the stage of the suit? (2016) petition. What is the date of the in which year the suit is filed? Suit is filed in which year? Correct. Then, yeah, why are you delaying it? ರೀತಿಯಲ್ಲಿ ಆಟಕ್ಕೆ ಆಗೋದಿಲ್ಲ. ನೋಡಿ ಯಾವ ಡೇಟ್ ಇದೆ ನೋಡಿ. Mister, you can argue this matter. Can you not argue? Correct, Appa. Can you not argue? Is it something beyond your comprehension? Correct. Can you not argue this matter? Why don't you answer that? Is it difficult for you to argue? Whatever that has to happen will happen. No, really, 2008 suit and you are still justifying an adjournment. Please argue. Let us see if you have any difficulty. I'll adjourn it. Any difficulty?
My lord, serial numbers.
Please wait.
Please.
Interim order idya? What is the stage of the suit? Suit ಯಾವ stage ಅಲ್ಲಿ ಇದೆ? Certain, please come back when the matter is called. Yes, Mr. Vinay Puttappa.
My lords, serial number 60, my lords. A week's time may be granted, my lords. My senior has some personal convenience. I've informed the other side.
Whom do you represent?
Petitioner, my lords.
At the request of the council for petitioner, list on 22nd.
My lords, interim order may be extended, my lords.
Interim order is extended till the next date of the
Lordship's kind permission, my lord. Serial number 49, my lord. The party is not in touch for the past 1 year, my lord. I have to take instruction. 2 weeks time may be granted, my lord.
Sorry, madam.
My lord.
2014, please don't ask adjournment.
My lord, in this matter, my lord, there is a probate which has to be questioned before Bombay High Court. I have told the client she has not got back to me after that.
2014, no adjournment.
2 weeks, my lord, because I have written a letter to
Sorry. Let us see what the case is all about. All these old matters, please don't take adjournment, madam.
Finally, my lord, because I have to contact the client.
Sorry, madam. Sorry.
Please.
52. Everybody is asking, doing the same thing. 2016 writ petition. What is this? Oh, sorry. Sorry, sir. Sorry. I agree. You please argue. You are capable of arguing. Next, sorry. Hale ಕೇಸ್ಗಳೆಲ್ಲ ದಯವಿಟ್ಟು 2020 ಕೇಳಿ 21 ಕೇಳಿ 22 ಕೇಳಿ take adjournment. I understand, but not in 2014, 15, 16, 17. Stay ಕೊಟ್ಟಿದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಹಂಗೆ ಉಳಿದಿರುತ್ತೆ. What will I please argue? Let us. Why were you implemented as a party?
I am not petitioner. I am not in turn not engaged partnership firm or shooting of video. So the petitioner easy. He is not a partner of that third entity.
The vehicle is insured.
Vehicle is insured. I am not the thing. I am not the owner of the vehicle.
Yes.
I am not the I am not the employer. In fact, all this was
Please take out notice. The claimant.
all was
No, what step? What is issue notice in addition, the learned counsel for the petitioner is directed to serve the learned counsel for the respondent number 1 before the tribunal. Notice to other respondents is dispensed. Date for the list on. What is the suit for? What is the land property? What is the suit property? Is it an agricultural land? Part and parcel property. ಹೊರಗಡೆ ಹೋಗ್ತೀವಿ ಫೋನ್ ಮಾಡ್ತಿರೋದು ಹೊರಗಡೆ ಹೋಗ್ತೀವಿ. ಸೌಂಡ್ ಎಲ್ಲ ಮಾಡಂಗಿದ್ರೆ ನೀವು ಹೊರಗಡೆ ಹೋಗಿ ಮಾಡಿ ಸೌಂಡ್ ನ. Invitation and verification, either the parties and the results. And you run a CD election tailor. And it can be tailor. The respondent number 4. The respondent number 3. They will take me the last before Issue notice. Addition, the learned counsel for the petitioner is directed to serve the learned counsel for the respondents before the trial. Till the next date of hearing, the parties are directed to maintain status quo with respect of the suitable property. So neither the plaintiffs nor the defendants shall put up any construction of whatsoever nature or demolish any construction that exists on the suitable property. Based on suit, and what is the suit for? What is the suit filed for? Cross-examination of which witness? The stage of cross-examination, period 1.
number 4. Last stage in different number 4 people report on our time is not different number 4 people one class report.
Delhi is out. Where is it?
Page number
60. Ah. Delhi 19? 1912. Ah. Plaintiff counsel present. You Ellers have brought on record. Notice. In addition, please wait. To notice. To notice to plaintiff number 1, 2, 3, 4. Sorry, respondent 1 to 4. Issue notice to respondents 1 to 4. Notice to respondents 5, 6, and 7 is dispensed for the present. In addition, the learned counsel for the petition is granted to serve the learned counsel who represented the respondents 1 to 4 before the trial court. In the next state of hearing, come up further proceedings. OS number 2489 of 2014. On the file of the PC report, PC report, Bangalore, records CH-9. 9 or 5? CH-9. CH-19. The state. List on 26 September. Passport. Who are you? From? Purchase the property from? Was purchased during the pendency of the suit or before that? At what stage this application was filed? So emergent notice. The trial is yet to be started. R sheet ಹಾಕಿದಿರಾ? R sheet ಅಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದೆ? Wherever mentioned, the trial is still not begun. The evidence, stage evidence ante ide. Trial has not begun ante helidire. Learned counsel for the petitioner submits that the trial in the suit is yet to begin, and that the petitioner was a pendenti lite purchaser of the suit property from the respondents, from the defendants in the suit. Stop in that view of the matter, comma, issue emergent notice to the respondent number 1. In addition, the learned counsel for the petitioner is directed to serve the learned counsel who represented the respondent number 1 before the trial court. Notice to the respondents 2 to 6 is dispensed for the present. Till the next date of hearing, comma, the further proceedings in invoice number 1042 of 2015 on the file of the 5th additional senior civil judge and CJ Mysuru is stayed. This time. Yes.
No prayer for arrears of credit. No work is here.
What is suit is for rejectment?
Yes, suit is for rejectment. And
What is your claim? What is your defense?
I have tried also over there. But doing the proceedings, what the pages, the lands, the stock being not supplied by access. Also complain to the restaurant parties and the so after the days of taking the food itself, I do not have water connection for the project. And within here, and reading block and shop right from June, July 2019.
No, sir, if you want to hang on to the premises, you have to pay rent.
But I am not able to use it.
Then you should have,
Based on this complaint,
you should have done something. You should have done something, filing a case, asking for connection, electricity, water connection. Have you done that?
those records are on.
Right, then you have to pay the rent. You have no other. You have to pay the rent. You are bound to. Correct. Then why don't you hand it over to him then? What about the arrears of rent?
Right from date of suit, July 2019, we are disconnected water supply. And in December 2019, I'm not able to do because we compared to shop, business. December 2019 onwards, I have connection A of place. Connection B is the father connected to government is not everyone. Actually, not very good to go ahead and pass government dated 2015. 2015 is when government government. The PPLP permission without taking the PPLP by agreement very clear not to do any illegal land supply. PPLP permission is the BSC criteria. Also, that is problem is 2015 is unmanned.
Yeah, seize ಮಾಡೋದು ಯಾರು?
BSC criteria so PPLP ಅವರಿಗೆ
GST ಅವರು ಸೀಸ್ ಮಾಡಿದಾರಾ? ಅಂದ್ರೆ ಈಗೇನ್ ಕಿವಿ ಮತ್ತೆ ಬ್ರೈನ್ ಎರಡು ಬ್ಲಾಕ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ ಏನು? ಹ್ಯಾಸ್ ದ GST ಅಥಾರಿಟಿ ಸೀಸ್ಡ್ ಇಟ್? ಅದನ್ನ ನಾನು ಕೇಳಿದ್ದು. So GST authorities, they are not seized it. ಅಲ್ಲಪ್ಪ, GST authorities seize ಮಾಡಿದಾರಾ? Mister, please keep your mind, brain, TV, tala ಎಲ್ಲ open ಇಟ್ಕೊಳ್ರಿ. Why do you come with a bulletproof head, mister? Tempers are unnecessarily raised in the court. ಕೇಳದೆ ನೀವು ಅರ್ಥನೇ ಮಾಡ್ಕೊಳ್ಳೋದಿಲ್ಲ, ಸುಮ್ಮನೆ ಏನೋ ಹೇಳುದು ಅದ ಮನ್ಸಲ್ಲಿ ಇವತ್ತು ಇದನ್ನೇ ಹೇಳ್ಬೇಕು ಅಂತ ತೀರ್ಮಾನ ಮಾಡ್ಕೊಂಡು ಬಂದ್ಬಿಡ್ತೀರ. If you have the license to run this salon and no, do you have a license to run the business? You have a trade license to run the business in this. No. If you want to hang on to the premises and if you want to fight with the BBMP, that is your lookout. So long as you're in occupation of the premises, you're bound to pay the rent. That is, it could be, Mr. If you don't have a trade license, it deserves to be seized. Correct? So please come to order 13. Please come to order 13 and rule 7. What inquiry? Do you admit the tenancy or not? You admit the tenancy? Not necessary. Not. Please read order 13 rule 7. 13 rule 10 na? 7. 13 rule 7 I think. What? Or 13 rule 10 na? He holds such money, not property. He holds such money.
Other thing that a trustee for another property, or that it belongs, or is due to another party. The court may order the same to be deposited or delivered to such last party.
So therefore you deposit the rent before the court. You deposit the rent. Not necessary. You please deposit the rent. You please deposit. The court will not order the rent to be released to him. Deposit in the court. Deposit it to the court. Order 20 rule 12. It will come only after the judgment is delivered. This is not mean profits. That is, no, that is if you do not admit the tenancy. So long as once you are at, we are not on that. If you admit the tenancy, you are bound to pay the rent. If you don't admit the tenancy and set up an independent claim, then you become an unauthorized occupant. Then the question of determining the mean profit would arise. If there is an agreement relating to tenancy, you are bound to pay the rent or deposit in the court. Not is that you establish, but you are bound to deposit the rent in the court. Rent to deposit money will direct the rent to be deposited in some fixed deposit till the suit is decided. Then you the first thing that you should have must have done is hand over the keys to him, arrest the accrual of the rent. If you want to do a salon, you're bound to invest. Therefore, you must first thing you must have done is you should have handed it over back to him. Correct. What should happen? No. What should happen to him? He is given the premises. Correct. When you have trade license, you don't have the trade license. You will deal with it in a different way. That's a different thing. How is he bothered about it? How is he bothered about it?
He is the one who is coming. He is the one who is He is the one who is in a suit where there is no player, no quality payment, not both sides.
Okay, now.
There is no prayer for arrears of rent. Without payment of court, we were asking to the recovery suit. Without inquiring on whether the rent is There has to be an inquiry whether rent is paid or not.
Please show something, some authority. Please show some authority. Well,
Since I'm not able to use the property, I will not contract.
sir, that is a question. That is a matter of trial. It's a matter of trial, but you owe a responsibility to pay the rent. So therefore, we are not asking you to pay it to him. We are asking you to deposit before the court.
Without business, I'm not even.
But that is your lookout, mister. That is your lookout. Password. Password, password. Password. No, no. Where is next? Password. Suit is what? Suit is what? What is suit property?
The partition being for the executed, the family member we have like 2000. After that, 2030, They don't have any other right.
Yeah. What is the trial court done? Injunction was granted. What happened to the appellate court? Issue notice. Bande, inna mugsila na. Issue notice. In addition, comma, the learned counsel for the petition is directed to serve the learned counsel who represented the respondent number 2020, respondent number 19. Respondents and respondents until the next date of hearing, comma, the petitioner as well as the respondents are directed to maintain status quo in respect of the suit's real property. Neither the petitioner nor the respondents shall put up any construction of whatsoever nature, and none of them shall remove or demolish any construction which exists on the suit property. List on. Huh? Start status quo, right? HR on. Power of attorney holder for the plaintiff. How old is she? But what is the suit for? Issue notice. In addition, the learned counsel for the people granted to serve learned counsel who represented the respondents before the trial court. Interim stay of further proceedings in US number so on the file of the so court. This time. I Tamil known next. For impleading. So who placed you in possession? Who placed you in possession? So he is your brother. So what does the other defendant say? What does the other defendant say? When was this application filed? At what stage? Cross-examination of? Issue notice. In addition, the learned counsel for the petition is granted to serve. The learned counsel who represented the respondent number one before the respondents before the trial court. Stop till the next date of hearing, further proceedings in US numbers also on the file of this so court is stayed based on what is the date of the agreement? Date of the agreement 16/1/2010. What is this rate of stamp duty? 4 rupees. Hello, sir. Avattina Dinankadando Karnataka Stamp Act alli ee daakle mele ಎಷ್ಟು ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಕೊಡಬೇಕಾಗಿತ್ತು? ಗೊತ್ತಿಲ್ವಾ? So therefore you should come out and say what is the stamp duty payable? ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ possession is given under the agreement. Possession is given. So what is the concerned article? 5E 2 ನಲ್ಲಿ ಬರುತ್ತೆ. 5E1 ಎಷ್ಟಿದೆ? 5E1 ನಲ್ಲಿ ಬಂದ್ರೆ ಎಷ್ಟು ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಕೊಡ್ಬೇಕಾಗಿತ್ತು? 2020 ಜನವರಿ 20ನೇ ಇಸ್ವಿನಲ್ಲಿ ಎಷ್ಟು ಕೊಡ್ಬೇಕಾಗಿತ್ತು? 0 point. That is if the possession is not delivered, Mr. Five E two ನಲ್ಲಿ ಬರುತ್ತೆ ನೋಡಿ. 5E1 ಎಷ್ಟಾಗುತ್ತೆ? Same duty as a conveyance on the market value of the property. ನಾನು ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿನ ಓದ್ತಾ ಇರೋದು, ಕೋರ್ಟ್ ಫೀ ಆಕ್ಟ್ ಅಲ್ಲ. ಕುಡಿಯೋದು. You should come prepared, Mr. What is the stamp duty payable on a conveyance? Conveyance is Article 20 ಹೋಗಿ ಸರ್. ಮುಂದಕ್ಕೆ ಹೋಗಿ ಹಿಂದಕ್ಕೆ ಹೋಗ್ತಿದ್ದೀರಾ? ಪಾಸ್ ಓವರ್ ನೋಡ್ಕೊಂಡು ಬನ್ನಿ ಕ್ಲೀನ್ ಆಗಿ.
For the petitioner, my lord, petitioners, my lord, petitioner number 1 is the plaintiff, and petitioners 2 to 4 are the defendants in the suit for partition, my lord.
Yes.
Lord, the respondents herein filed an application for impleadment, IA number 7, on 16/11/2019, as per Annexure C, page 25. This application,
who is this impleading applicant?
They claim right in respect of item numbers 5 and 6 of the suit scheduled properties.
They are purchasers.
No, they claim right. They say they are in possession of the property.
In what capacity?
Not they say not that they it was an Inam land and they were put in possession. So many things they say. Not ultimately their right has to be educated in a separate suit. Not if they file. Lord, the suit was filed in respect of 15 items of the properties.
Correct, but if they are claiming independent title,
Yes, my lord.
can they not establish before the court that this property is not available for partition?
Lord, even then, my lord, IA number 7 was filed and it was dismissed for default. An application was filed, IA number 9, for restoring, recalling that order. In the meantime, Lord, parties, the original parties, that is the plaintiff and the defendants, they negotiated for a settlement in the presence of well-wishers and they filed a compromise petition. That compromise petition was filed and it was heard on the same day and it was posted for orders. No orders were passed on that application, on that compromise petition. IA number 7, which was dismissed for default, which was not available for orders, Lord, that has now been allowed. Without hearing, Lord, without that order being recalled. Lord, the impugned order is at page 73, Lord, 74. Previous page, my lord, your lordships may kindly see, Lord, at page 73. On 17/6/2022, my lord, compromise petition is filed, heard for orders by 8/7.
Right, but see, if there's going to be a proceeding,
Yes.
if there's going to be a decree,
Yes, my lord.
against a property,
Yes, my lord.
are these people not entitled? That is why I asked you whether they're claiming through you, through the defendants, or are they establishing,
Lord,
trying to establish?
that application, my lord, I have placed it on record, my lord. Page, my lord, 25 is the application, IA number 7. 27, my lord, is the affidavit.
Yes.
I came to know that the para 2, my lord, I came to know about the pendency of the case before the honorable court recently when plaintiffs came at item number 5 and 6 of the plain scheduled properties and discloses that he has some right and interest in the properties. But he has disclosed that so and so. Para 3, I respectfully submit that properties bearing Jodi number so and so claimed in P&SC number 8 of 2007 are the Jodi Namti lands belong to Narsimachar, Jodidars of Jiganhalli village. One Lakshmi Narayanachari and Ramachari are brothers who are sons of Ramachandrachari. The said two persons were tenants under the above said Narsimhachar. After abolition of Jodi villages, they have filed application before Additional Deputy Commissioner for Inam Abolition, Bangalore for confirmation, etc., etc. Lord, if at all they have any independent right, Lord, it is always open, Lord, for them to file as an independent suit. Lord, in my
Correct,
suit
but
for
why should they
partition-
allow a decree to be passed against that property?
Lord, in my suit for partition, Lord, they are not necessary parties at all.
Correct, but why should they allow a decree to be passed against their property?
Lord, ultimately, Lord, in a partition suit, Lord, a third party is not at all necessary party, Lord.
Your final decree proceedings, Ali,
Yes,
can they not come before the court? Of course, preliminary decree, court can always say,
Yes.
decide the right of the parties.
yes, Lord.
But in final decree, can these people not come on record and say that this property is not available for partition? Can they not?
They can, my Lord, but as on this date, my Lord, they have to establish their right, and they can come on record in
I
the.
think what the court is done is correct. If they have got some semblance of right and they're not claiming under the defendants,
Yes, my Lord.
they're entitled to come on record.
My Lord, that application was not at all heard, my Lord. Even the order, impugned order, does not say that application was heard.
Correct. IA for recalling that order, rejecting that application for non-prosecution,
Yes,
that is recalled.
No, my Lord.
Again, allow it,
IA7 impleading application ಅನ್ನೇ allow ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ.
Right. Then we'll direct the trial court to hear this application afresh. ಅಷ್ಟೇ ಆಗೋದು.
ಅಲ್ಲ, ಈಗ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಬೇರೆ ಇದೆ. That has to be considered, my Lord, and
No, now that the order rejecting this application
yes, my Lord.
or dismissing this application for default
Yes,
has been recalled.
No, my
Then
Lord,
the-
it is not recalled, my Lord. IA number 9 is also pending consideration. IA number 9 is filed for recalling the earlier order, dismissing IA number 7 for default.
ಏನಾಯ್ತು? IA9 ಏನಾಯ್ತು?
IA number 9 ಕೂಡ not heard at all. It was not taken up for hearing.
Then how could the trial court allow the application?
Lord, that is my exactly the grievance, my Lord. IA7 was not at all available, my Lord, for consideration. Since IA number 9 is not yet ordered.
Sir,
Page
in
7.
view of the SOP dated 4/2/2022 of the High Court of Karnataka,
Yes,
the earlier order was revoked.
yes. ಅದು ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ ಅಂತ ಮಾಡಿದ್ರು, ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ್ರು ಸಿಟ್ಟಿಂಗ್ ಅನ್ನ, ಅದು ರಿವೋಕ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇ.
Here on IA7 to here on IA7,
Hmm.
he was on leave. IA number 7. ಇಲ್ಲಿ dismissal ಆಗಿತ್ತಿದು.
ಇದು ಪೇಜ್ 71 ಆರ್ಡರ್ ಶೀಟ್ ಡೇಟೆಡ್ 17/12/2021.
17/12.
ಹೌದು.
ಓದಿದೆ.
Application filed so and so, no representation since long, no arguments on IA number 7, hence IA7 is dismissed for non-prosecution.
Yes, ಅದಾದ್ಮೇಲೆ ಏನಂತ ಬಂತು?
Call on for plaintiff's evidence.
In a notification dated 14/1/22.
Yes.
The fighter report to the son for the census matter was adjourned to full question. IA number 9.
IA number 9 is for under 151 for recalling that earlier order. On IA number 7, dismissing for default.
We can only regularize this proceeding ಅಷ್ಟೇ, ಇನ್ನೇನಾಗೋದು.
Lord,
ಅಷ್ಟೇ ಆಗೋದು, ಇನ್ನೇನಾಗೋದು.
application, unless application IA number 7 was restored, Lord, and it was considered, compromise petition could have been ordered, Lord, and relegating the parties to the proper forum, Lord.
IA number 7 was dismissed for non-prosecution.
Lord, and that was yet to be recalled, Lord.
ಆಯ್ತು, ಇವಾಗೇನ್ ರಿಕಾಲ್ ಮಾಡಿ we'll direct the trial court to recall, rehear it.
The application, my Lord, if the trial court itself deems fit to dismiss, my Lord, then
We'll recall that order,
please.
dismissing IA number 7. We'll direct the trial court to rehear it.
Lord, that application, my Lord, we have objections to that application, my Lord, and we are yet to be heard on that application, my Lord.
Issue notices. Issue notice in addition, the learned counsel for the petitioner is directed to serve the learned counsel who represented the respondents before the trial court. List on 26 September.
Lord, I have sought for stay of further
No,
proceedings,
no.
Lord.
What is there to be stayed? Compromise petition ಹಾಕಿದ್ದೀರಾ? What is there to be stayed?
ಅಲ್ಲ ಈಗ ನಮ್ಗೆ ಅವ್ರನ್ನ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆಗಿದೆ, ಅದು ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಕೊಂಡು ಎವಿಡೆನ್ಸ್ ಮಾಡಿ ಅದು ಮಾಡಿ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್.
Commercial suit is correct.
Hmm.
Recovery of the invoice amount
Hmm.
for supply of the RNC. The defendant enters appearance, denies the transaction. But at the time of dating evidence, I get a list of witnesses. Two of the witnesses with whom there are correspondences by the defendant reflecting upon the existence of the transaction. It is ought to be produced by means of an application with the documents. That application is rejected. The trial court refers to finding at page 1. Unless I disclose the existence of the documents, or if the documents are due subsequently, unless I disclose that these are the documents because not in my custody, it is not permissible to read the documents. But what the commercial court has to take into account is order 11 rule 1(1)(c) as amended.
Yes. Order 11.
Order 11 rule 1(1)(c), which those speaks about the disclosure of the documents. See,
Order 11 rule 1(c).
11 rule 1 speaks about disclosure and disclosure of the documents.
Correct.
These are the documents that are sought to be produced to the witnesses we are going to period 3. Clause C.
ಎಲ್ಲಿದೆ ಕ್ಲಾಸ್ ಸಿ ಎಲ್ಲಿದೆ? ಕ್ಲಾಸ್ ಸಿ ಇಲ್ವಲ್ಲ ನಮ್ಮ ಬುಕ್ ಅಲ್ಲಿ.
ಅದು commercial court
ಅದು ಕೊಡಿ. ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ಸ್ ಆಕ್ಟ್. Yes. Yes.
Nothing in this rule shall apply to documents produced by the client in government only for the cross-examination of the defendant is or if answer to any case set up by the defendant subsequent to filing. The one contingency where subsequent documents can be produced. Process may also have a look at Order 16 rule 1 capital A.
Yes. Yes, please go on. Order 16.
Order 16 rule 1 capital A. It is not amended.
Yes.
Production of witnesses becomes subject to provisions of subgroup rule 1. Any party to the suit can apply for some rule 1 be investigated.
But order 11 ಯಾಕೆ ಹೇಳ್ತಿದ್ದೀರಾ ನೀವು?
I'm happy to indicate that there is an exception provided under the scheme of the commercial code books itself, where the documents are required for the purpose of answering. But for a defense if it is raised by the defendant, then this exception is not applicable.
Notice. Petition the counsel for the petitioner is directed to serve the counsel for the respondent. But these documents were available with you.
These are the documents to which I am not a privy. PW2 and PW3 are the petition documents. Correspondences between PW2
Who are they? Who are they? PW2 and 3. Who are they?
PW3 are the marketing representatives of the
ಮತ್ತೆ ಅವ್ರ ಹತ್ರ
they will be having very entities. They email entities. They have corresponded with the defendant regarding this transaction. It will not come to my server.
when you're filing the suit, don't tell me that you will not ask your agents. When filing the suit, will you not ask your agents?
There are invoices which are acknowledged by the defendant. First, the data I will get page number 10. There are invoices which are acknowledged by the defendant. Defendant gross the page number 10 gross I have stated. This is a claim. Paragraph number 6.
To notice, in addition, the responsible counsel directed to serve the learned counsel who represented the respondent before the trial till the next date of hearing. Further proceedings in so and so before the so and so court is stayed. List on 27 September.
Serial number 13 appear for the petitioner. Ma'am. Right, the acceptance of paper publication.
The petitioner has taken out notice to the respondent number 2 by substituted service to publication in Mysore Mitra,
Mysore Mitra and Andolana.
Kannada daily newspapers having circulation in HD quoted, where the respondent number 2 ordinarily resides. Respondent number 2 is known to be last residing. Stop. The respondent number 2 is called out and is absent. Hence, notice to respondent number 2 is held sufficient. Office is directed to show the name of the respondent number 2 as served in the process.
Interim order has to be extended.
Interim order is extended till the 2016 year, but
Posted for B group, my lord. It may be posted for B group or next week.
Don't ask for Angidra now B group matra hearing thought.
Next week it may be posted in the orders itself.
In facts here, but on the facts.
I'm not the regular counsel. My friend has asked me to.
The request of the law counsel for the petitioner list on so and so. Interim order is extended till the next date of hearing. Date could be 23rd September.
Please.
Please give a handle with me. The counsel for the petitioner is now designated as a senior counsel. Hence, office is directed to issue notice to the issue court notice to the petitioner. List on. Password. Process 50 R3 and R4. Password, Mr. Password. Whatever you want, madam. Then the internet will not continue. Please do it. Yes. When did he die? When did he die? Issue number 17. Like there or you are the children of children number 1. You are the legal heirs. Yarar Manjula Govinda. Kempamma is dead, Mr. Kempamma Tirogirodu. Who are the legal heirs of Kempamma? I think D2 ಆಗ್ತಾರೆ. D2 is Govindappa, son of Ramappa. Kempamma is the wife of Bayanna. Yes, Mr. Tigdi.
Note 17. I will pray for time. I'll find out whether she has left behind any LR sign. Because plain does not disclose anything.
ಯಾವಾಗ ತೀರೋಗಿದೆ ಇದು 2016 ಅಲ್ಲಿ ತೀರೋಗಿದೆ ಅಂತ ತೋರಿಸ್ತದೆ.
Find out now. Get instructions from instructing advocate and
No, but you have implemented a person who is dead. You arrayed a person who is dead. The respondent number 1 is stated to have expired, which is evident from the order dated 19/10/2016 passed by the trial court. That way of the matter, the requisition as against respondent number 1 as abated. Memo is filed to withdraw the petition. In view of the memo, the petition is dismissed as withdrawn. 2 weeks time is granted to do the need. Non-filing of necessary application by advocate for petitioner. File ಮಾಡಿದೀರಾ? Legal counsel for the petitioner submits that he has filed application to bring the legal representatives of the deceased. Yaro, petitioner. Post of office to check, verify and put up. 2 weeks time is granted to do the need. ಇದನ್ನ ಮುಗ್ದಿಲ್ವ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಅವಾಗಿಂದ ಹೇಳ್ತಾ ಇದ್ದೀರ ಬೇಕು ಆಗುತ್ತಾ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ದ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಪಿಟಿಷನ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಲಿಸ್ಟ್ ಆನ್ ಲಾಸ್ಟ್ ವೀಕ್ 29. In the meanwhile, counsel for the petitioner is directed to pay the process to issue notice to the unserved respondents. Mr. Second, we do not know why it is returned. Check madi address serigena fresh address kudi. So therefore, please do it before the next date of hearing. First check madi yenane return agide. So therefore, yaar kodbeku address? Insufficient address kodang paper publication ಮಾಡ್ತೀರಾ? Mr. Please come to order 5 rule 20. ಓದಿ ಏನಂತಿದೆ last known address ಅಂತ ಇರೋದು. So therefore, please furnish the last known correct address. ಆಮೇಲೆ ಬೇಕಿರೋ paper publish ಮಾಡಿ. The amount is extended to the next set. 1 week time is granted to do the needful, failing which the petition shall stand dismissed without reference to bench. 2 weeks time is granted to do the needful. Who dispose agidya? What's your name? The learned counsel for the petitioner, Srimati Swanso, representing the learned counsel for the petitioner, submits that the petition has become infructuous since the suit itself is disposed of. Since the proceedings before the executing court itself is disposed of, in view of the aforesaid submission, the petition is dismissed as having become infructuous. 2 weeks time is granted to do them. 3 weeks. 3 weeks time is granted to do the need. List after service of notice to the respondents 1 to 6. 27 number. 27. Let the notice be served. 2 weeks time is list after service of notice to respondents 1 to 6. In the meanwhile, office objection shall be complete. Interim order is extended to the next set of hearing. Same order. List after service of notice to the respondent. Interim order is not ready.
29 appearing for the petitioner, please, Your Lordship. I have served upon the respondent, please.
Yes. You accept notice. The respondent is represented by counsel, hence office objection does not arise. Survive for consideration. Yes, what is the case?
This is a suit for recovery. 2 questions of law arise before Your Lordship. One is on Order 11 Rule 14 application was filed during the cross-examination of PW1, please, Your Lordship, in which I have requested for ITR and certain ledger books which during the cross-examination, the PW1 has admitted that he is in possession of the same, and he can produce if the court asks to do so. So therefore, I filed his application. The Honorable Court has the order is that it is kept in abeyance till conclusion of cross-examination, please, Your Lordship. So there is no particular order as such which is filed on this application. Now, second, Your Lordship, there is a memo I had filed. One Mr. Amit Anand, the advocate, is the brother of the plaintiff, please, Your Lordship, in the suit. And during the cross-examination, he has admitted that said Amit Anand is a witness in this particular suit, please, Your Lordship. And certain emails have been produced from the ID of this particular advocate. And at the time, he was not on Wakalatnama also. Subsequently, he filed Wakalatnama. So I filed a memo saying that under Rule 13 of Bar Council of India rules, he cannot be permitted to be appearing as an advocate when he is a witness, please, Your Lordship. In that regard, the trial court has said that this I should approach the concerned authority, please, Your Lordship. My respectful submission is, Your Lordship, that when then illegality is happening pertaining to this thing, the court cannot go behind that and say that I have to approach the competent authority. I have no personal thing against that particular advocate, please, Your Lordship, but it's in clear violation of the Bar Council of India rules. Therefore, there are other advocates who are appearing in the particular suit, please, Your Lordship. So these are the two considerations before Your Lordship. One is the 11 Rule 14 which is kept in abeyance. The documents are necessary, please, Your Lordship, before the cross-examination. So I want to confront those documents to the witness, please, Your Lordship.
Yes. Here's the cross-examination of PW1, where he says that he can produce these documents.
At page number 42, please, Your Lordship, I produce the deposition.
The cross-examination of PW1, where he was asked to produce his ITRs.
At page number 43, please, Your Lordship.
Please come to page. Please wait.
All right.
Yes. But this transaction is with the in-swinger itself or? No. Whether in-swinger
I'm not now reading also.
Now, whether this in-swinger is it's a proprietor concern.
It was. And that was nothing to do with the transaction. And the sponsor application. I took the relevant period. Before it is satisfied. Then after that, it is proceeding for implementation. And my 12 agreements are taken out. We do it. And can you see the input order? If I say review of the data.
So if you have these documents, you produce it, will direct the cross-examination to be conducted on one particular day. No further procrastination. Yata Vandina,
Please, Your
produce this document, we'll ask him to conclude the cross-examination one day. On one day, no further adjournments. But the problem is, see, in-swinger is a proprietary concern, which is identifiable with the plaintiff himself. So therefore, whether it is done as proprietor of in-swinger or as Anand Singh, it hardly matters. Correct. Yes. ಆಯ್ತು ನೀವು ಇನ್ ಸ್ವಿಂಗರ್ ಕೊಡ್ತಿದ್ರು at least you please furnish the income tax returns for the year 2012 and 13. So our plaintiff is concerned. Forget in swinger. Plaintiff to ಕೊಡಿ. Yeah. 12 to 18. Why do you need for the assessment year 12 to 18? If the transaction has happened according to the plaintiff in the year 2017.
Lordship, 2012, actually the contention of the defendant is
Let us see
that
what
there
the
was a
plaintiff
true-net.
Let us see what the plaintiff says. When he paid the money to you. When did the plaintiff pay the money to you?
2017, please. Your Lord.
So therefore, you're only concerned with that. Why to 2012?
Yes, Your Lordship. That same question had arose even before the trial court. The defendant's contention is that there was a scheme, one scam is there, a multi-level marketing scam, which the plaintiff was conducting, wherein he was.
Merits of the case. Plaintiff
Yes.
says he paid the money to you in the year 2017. So for the financial year 2016-17. Let them.
There were certain transactions which were pertaining previously. Selected documents have come forth before the court, and the true facts have not come forth. There are certain money which were transferred both ways, which are there, please, Your Lordship, in those particular transactions. That is why I have asked for that ledger books and bank account statement and balance sheet, please, Your Lordship.
Whatever you want, you can ask only from March 2017 onwards. Not before that or not beyond that. Okay, beyond that is okay, but not before that.
Lordship, the introduction of the defendant happened around that same time, and that is the contention.
When was the transaction? When was the financial transaction between the parties? Somewhere
According
in
to the
MOU was drafted as early as on 22/5/2017. So therefore, from March 2017 till date, or till the date of filing the suit.
Lordship, it's a restaurant which is catering business, what that Messrs. Inswinger is conducting. But behind the back, there are certain funds which were flowing both ways, and therefore that particular statements and the accounts will be prejudice.
Please show in the written statement where have we mentioned all those funds, flowing of funds.
Lordship, the written statement, annexure B, please, Your Lordship, produced at page number 29.
In the year 2012.
Late, that's when they got introduced. He introduced him to that particular scheme, please, Your Lordship, where he had to invest in that particular scheme. and that is the defendant's contention.
That is right, but you must have paid the money through some proper channel, isn't it?
It is all rerouted through multiple people, please, Your Lordship. That is his contention. The contention in this entire case is not the dispute with respect to the money given, but the purpose. It was not loan, please, Your Lordship.
Correct. In the year 2012, there is only one transaction, according to you.
Yes, Your Lordship.
2,38,000 in the year 2012.
2,38,000 he had invested, please.
Thereafter, what was the other investment? The defendant number one on the pretense of making training programs and collected was 40 to 50,000 per event, which were conducted in foreign nations or in India.
So yeah, the defendant had to get certain other people also to join the scheme. That's how the multi-level marketing scheme works, please, Your Lordship. We had to get more people to sign up for that scheme. They also end up paying that particular amounts, please, Your Lordship.
That is right, but these are things correct. So better to add clarity to the whole case. But you produce all your account extracts to add clarity. Who is wrong, who is right, and the Tilkobakala court. So therefore, we'll say we'll direct the trial court to permit the defendant to cross-examine PW1 on one date or 1 or 2 dates, not more than 1 or 2 days. Produce my document. Sir, you produce these documents. Produce these documents. Within 2 days, you'll conclude the cross-examination. If it overspills, then we'll direct the trial court to close it. This is such a complex transaction. According to the defendant, it's a complex transaction. Then I'll have to call for the records and find out whether defendant. Whether he has produced the documents or not, call for more. But it makes sense for you to. But court has to decide that, isn't it? If the court has to decide it, then it should have everything before it. To substantiate the benefits. If you want me to call the records, I'll call the records if you want. So therefore, you please. Now this application is not rejected. It is only kept on hold for some time. So therefore, we'll direct the trial court to go on with the, or direct the defendant to go on with the cross-examination. Yes, Mr. Go on with the cross-examination. The next date, we'll direct him to produce it before the. and thereafter you can cross-examine him.
Please, your lordship, because I want to confront those documents to him. That is the only thing, please, your lordship.
Purple.
And second part also, please, your lordship.
Second part we'll consider it later, not now.
Please. Your
Purple. The petitioner has challenged order passed by the trial court and on an application under order 11 rule 14 of CPC. But the petitioner has challenged, the petitioner being the defendant in voice number 2363 of 2020 is aggrieved by the order dated
4th July 2022.
4th July, huh?
4th July.
4th July 2022, by which an application filed by him under order 11 rule 14 of CPC.
But lordship, that is a review. Section 114 application read with 151, please, your lordship. It's a revision which was filed.
What is the order dated? 47, huh?
47, please. It's at page number 78 of my petition. The application is at page number 73.
Mr. Why are you unnecessarily delaying the proceedings in the suit? What was the need for it? Oh, please tell me, what was the need for you to file a review application? When the court has said, no, please wait. When the court has said that this application will be considered later, why did you file a review application?
First, it was rejected. Please.
So why did you file a review application?
First, it was rejected. It was against me. So I asked the court to reconsider. The court said it will be kept in abeyance.
Yes. Where is the earlier order rejecting the application?
Earlier order, please.
Where is the defendant?
It's on page number 72, please, Lord.
Yes. What is this application?
Second last paragraph. Page number 72, please.
But this application is filed under what? Order 14 rule 3.
No, 11 rule 14, please.
So review then ಮಾಡಿದಾರಲ್ಲ.
It's a combined order, please. 7 rule 14.3 has been filed by the respondent, and that was allowed. I have not challenged that.
Article 47/2022, by which an application 4722 by which an application filed by the defendant under section 114 of the Code of Civil Procedure is disposed of, and the application filed by the defendant under order 11 rule 14 of CPC was kept in abeyance to the conclusion of the cross-examination PW1. Stop. Next para. When the writ petition was listed for consideration before this court, the learned counsel for the respondent submitted that in order to expedite the suit, he would produce the document sought for in the application filed under the learned counsel for the respondent conceded to the suggestion made to the court. Conceded to the suggestion made to the court and accepted that he would produce the documents as sought for by the defendant if sufficient time is granted to stop. However, he submitted that the defendant is unnecessarily delaying the proceedings in the suit, and therefore he may be directed to proceed with the cross-examination of PW1 on the next date of hearing, and that he may thereafter cross-examine PW1 after the documents are produced. Stop. The learned counsel for the petitioner has no objection to do so. In that view of the matter, pending disposal of this petition, the petitioner is directed to go ahead with the cross-examination of PW1 without seeking any adjournment on the next date of hearing. Stop. The plaintiff shall produce the documents before the trial court as sought for by the defendant in his application under Order 11 Rule 14 of CPC within 2 weeks. Within 2 weeks. Within 2 weeks from the next date. Within 2 weeks. Within 2 weeks from the next date of hearing. To stop, the trial court may permit the defendant to cross-examine plaintiff, cross-examine PW1 on the document so produced. After granting reasonable time to the defendant to verify the documents. We'll stop. This list on list on 30th September 2022 for further orders. Go on with the classification. Just after service of notice. Just after service of notice to the respondent. 18/8/22. ಇನ್ನ ಎಷ್ಟು ಕಟ್ಟಬೇಕು? ಇನ್ನ 2 weeks. The request of the learned counsel for the petitioner, 2 more weeks time is granted to comply the order dated 1/8/2022. It is made clear that no further time will be restricted to comply the order dated 1/8/2022. Just after service of notice to the respondent. Uttade 2 ವಾರ ಅದರಲ್ಲಿ ಇವಾಗ 3 ವಾರ ಕೇಳ್ತಿದ್ರು. Defendant number 5. Right, but what about this 1 and 4 ಬೇಕಾಗಿಲ್ವಾ? ಮೆಮೊ ಕೊಡಿ. ನೀವು R5. Mr. V.B. Shivkumar accepts notice for respondent number 5. Office is directed to show the name of Mr. V.B. Shivkumar as the counsel for respondent number 5 in the cause list. Next, a memo is filed by the learned counsel for the petitioner to dispense notice to respondents 1 and 4. In view of the memo, notice to respondents 1 and 4 is dispensed at the risk of the petitioner. If they are unserved cover refused and R5. So yes. Yeah, what is the suit? The petition is filed by the plaintiffs, the plaintiff in OS number 1068 of 2004 on the file of the so-and-so court. Agreed by the order dated so-and-so by which the court rejected an application filed by her to recall DW1 for DW1 for cross-examination. Expert. The suit in OS number 1068 of 2004 was filed for declaration, injunction, declaration, recovery of possession, and declaration that she is the owner of the suit property, and for mandatory injunction to demolish the construction put up over the suit property and to deliver possession of the same. Full stop. The suit was contested by the defendant number 5, defendant number 5, who denied the claim of the plaintiff. Full stop. After the suit was set down for trial, the defendant number 5 was examined as DW1. However, he could not be cross-examined. However, he was not cross-examined, and he was therefore discharged. An application was filed by the plaintiff to recall DW1 for cross-examination, which was rejected by the trial. Stop. Agreed by the said order, the plaintiff respects this expedition. The learned counsel for the plaintiff submitted that the plaintiff could not contact her advocate to give instructions for cross-examination of DW1. Further, she has stated that on 14/6/2022, her advocate was preoccupied in another case. Therefore, he could not cross-examine DW1. Stop. The learned counsel for the defendant number 5 submits that even after granting adequate opportunities, DW1 was not cross-examined, and therefore the trial court was justified in rejecting the request to recall DW1 for cross-examination. Madilva to Solpa Madika. Madilva. Next, for having regard to the suit reliefs, it was necessary that an opportunity must be granted to the plaintiff to establish her claim in respect to the suit property. In that way of thinking, though the order passed by the trial court is unexceptionable, yet in order to grant an opportunity to the plaintiff to cross-examine DW1, this repetition deserves to be allowed. Consequently, the repetition is allowed. Hence, the application filed by the plaintiff to recall DW1 for cross-examination is also allowed. The DW1 shall remain present before the trial court on 24th, on 24th September 2022, and he shall be in a Sheena, and he shall be cross-examined without fail on the said day. The repetition stands, allowed ಅಂತ ಬರೆದಿದೆಯಲ್ಲ. That along with WP number 15416 of 2022. The R6 jari the Radhan.
R6
Yes.
the order related to
It is stated the bar that the respondent number 6 is not a necessary party to this expedition, as the impugned order is only against the 1 to 5. Hence, notice to R6 is dispensed. Yes.
So that is the
This is not maintainable on the order. Yeah, what is the order which is challenged? What is the order that is challenged? So that can be urged in a miscellaneous first appeal.
Cannot be granted.
But whether a leave to file a suit is already granted. Not yet granted.
Yeah, section 92. There is still an inquiry going on. There is plenty of people who are passed without granting this. So the question was to eliminate state of the product could be whether or not the interlocutory was could be passed in absence of this. That is the question which will be there on a technical ground. There. Acting in the there is one more entity. There are several copies of this.
Office is that list is equal to along with WC number. So if you come, no, if you come, you have to list on date, could you have the available date is ಏನ್ ಎಲ್ಲಾ ಕೇಸು ನಿಮ್ಗೆ ನಾಳೆ ನಾಡಿದ್ದು ಆಚೆ ನಾಡಿದ್ದು ಲೆಟ್ ಇಟ್ ಕಮ್ ಲೆಟ್ ಇಟ್ ಸ್ಟೇ ಇನ್ ದ ರಿಜಿಸ್ಟ್ರಿ ಫಾರ್ ಸಮ್ ಟೈಮ್. I don't understand the anxiety of getting your matters listed within a day or two of its posting for complaints of office objections. I don't even understand the anxiety. Let it come, Mr.
The reason why. And plus they not be elected to be.
Let it come. Next.
Someday next week.
All right.
Someday.
It will come. Next. This is serial number 34. Let notice be served, madam. Please file an affidavit. We'll issue notice to the lawyer. Where's the memo? Who's the advocate, madam? What's his name? What is his name? The memo is filed by the, sorry. In compliance with the order passed by this court, comma, this court in terms of the order dated 24/8/2022 had directed the learned counsel for the petitioner to serve the learned counsel who represented the respondent number 1 and 2 before the trial court. The memo is filed by the learned counsel for the petitioner petitioner stating that the learned counsel who represented the respondents before the trial court refused to receive the same, and that stop. This is the same. Stop in that way of the matter, comma, issue notice to Mr. Yarido. Mr. N. Ramachandraya. What's his address, madam? Ramachandraya, Kolar. Kolar, huh? What's his address? N. Ramachandraya. There. Advocate Kolar. Please give the address, madam. Please give the address. So whatever it is, when a court has issued notice, the lawyer is bound to accept it. He cannot say no. He should accept it and do whatever he wants. He may appear before the court, he may not appear before the court, but he has no business to refuse. There is no business to refuse. There is no right to refuse, rather. Please furnish the address. Directing him to appear before the court, before this court on 27 September 2022, failing which appropriate proceedings should be initiated against the council. Let it come, please let him come for yes. The compromise was reported in the suit. What is? Let the notice get served, madam, to the advocate. Let it come. Let it come. Please serve it. Please give the address first. Please give the address. And without the presence of the respondent's counsel, can we dispose of the petition? Please tell me. Dismissing his suit. Yes. First, notice kudi, address kudi. Please furnish the full address. Next. Date is given as 23rd September 2022. Other numbers to be stated, issuing authority to be stated correctly, prayer and prayer. Issuing authority in the page number?
Therefore, the petition filed an application seeking referral of the document to the concerned district register of stamps. The trial court, before assigning any reason for the order, rejects the application as not maintained. And records that the petitioner want to pay the stamp duty and hence for payment of stamp duty. But the document is produced, the court has not acknowledged the document. Either referring the document to the probate authority. Therefore, the petitioners are unable to pay the stamp. And it's not a speaking order.
Where's the document?
The document. Total has paid 31. Which is 110 has been paid on the document. The court below counsel considers that it is illegal to pay stamp. However, it does not actually any reason as what is illegal to pay stamp. Therefore, an application was made for reference.
1991 lane stamp. 1991.
110 has been paid on the document. However, since the court was under the impression that the document was insufficiently stamped, It's not for reference to the competent authorities, so the competent authorities to have a.
Oh, once a document is produced before the court, there's no question of referring it before the competent authority. That is a law declared by this court. December what is judgment today. Correct. So the division bench of this court has taken a view that once a document is produced before the court has to do it, not.
In fact, in the affidavit, the petitioner has specifically say that petitioner is willing to give a requisite standard rules. Suppose you have imported a document and that report, and you have to tell 10 times what the petitioner is undertaken to pay. So that without importing the document, without directing the office.
So therefore, you please tell us what was the stamp duty payable on this document as on 10/10/1991. How much is paid?
110.
Why do you say it is insufficient? This time? Where is that order? Where is the order? Yes.
Dependent council filed ID number 1600, section 151 CPC. This ID number 16 is not maintained. It is rejected. Dependent council again submits one to pay the stamp duty and grant. As for payment of stamp duty, then grant. But if the document was referred to the office for assessment, the petitioner would have paid the requisite stamp duty if the office came to a conclusion that it is insufficient.
Issue notice. Conditions once for the petition is granted to serve the land council who represented the respondent to the character. Stop. Until the next date of hearing, further proceedings in US number 983 of 2016 on the file of this Swansea court is stayed. This on. In the meanwhile, office objections will be complete. Shall be complete. Even IA1 of 22, any objection, therefore IA1 of 22 is filed by the applicant for the legal heirs of the deceased petitioner. Stop. Since the cause of action survived the death of the petitioner, IA1 of 22 is allowed. The applicants are permitted to come on record as the legal representatives of the deceased petitioner. Counsel for the petitioner is permitted to amend the cost structure and file an amended cost structure within a period of 1 week from today. The interim order granted early is extended till the next year. So 15th ಆದ್ಮೇಲೆ ಕಾಲ್ ಮಾಡೋದಲ್ಲ. Yes, 15th ಆದ್ಮೇಲೆ ಮಾಡ್ಬೋದಲ್ಲ. ಅಲ್ಲಿ ಸೂಟೆ ಡಿಸ್ಪೋಸ್ ಮಾಡೋದಕ್ಕೆ ಹಾಕಿದಾರಲ್ಲ, ಅದಾದ ನಂತರ ಹಾಕೋದಲ್ಲ. ಇದು ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಆಗ್ಬಿಡುತ್ತಲ್ಲ ಒಂದ್ ವೇಳೆ ನೀವು ಗೆದ್ರೆ. Since it is stated at the bar that the application filed for rejection of the plaint is heard and is reserved for orders on 15/9/2022 based on 20th September 2022. Interim order is extended till the next date of hearing.
Lord, I am for the petitioner in this case, my lord. This is suit is filed for setting aside the impugned order passed by the lower court.
Who are these proposed respondents 2 and 3?
My lord, proposed respondents are the principal debtor and the surety, first surety, who is the husband of the defaulter.
So were they not arrayed as parties in the civil court?
Please, my lord, because the backdrop of the case goes like this. The petitioner herein stands as a third surety for a chit amount, and the respondent number 1 is the chit company which floats a chit for 25 lakh rupees with a monthly subscription of 50,000 rupees, for which the proposed respondent number 1 joins as a party and she wins the bid. And she has taken the total consideration amount of 16,04,000 rupees 625 after bidding amount. And subsequently, her husband stands as a first surety. And the second surety stands as her relative, and third surety stands by the petitioner herein. My lord, the principal debtor, after availing the chit amount, she has paid 33 installments, and thereafter she becomes default from 18/4/2018. In the meantime, as a surety, her husband surety number 1 and her friend surety number 2, and the petitioner herein stands as surety number 3. After she becoming default, the company lodges a dispute with the registrar of chits at Udupi and secures an ex parte order for the recovery of the outstanding amount. Subsequently, the respondent number 1 herein, the chit company, files an execution suit omitting the principal debtor, the defaulter and her husband purposefully, and making party to that surety number 2 and 3 herein, and they secures a order of salary attachment for surety number 3.
The husband is also surety.
The respondent number 3 is surety, and 4 is also surety.
The proposed respondent number 2
is husband of the defaulter, also the first surety. The question here is, my lord, actually the respondent number 1 herein should have made both of them as a party to the execution suit at the lower court, and they should have proceeded according to the law.
Where is the certificate issued by the authority?
My lord, the certificate
of recovery.
It is page number 17 to 21 of the writ petition, my lord. Whereas the award is a certificate of recovery is issued as against all the 4 of the defaulter. But thereafter, instead of making all of them as a party to the execution petition, the respondent number herein chooses only to make a party to the suit the surety number 4 as well as the petitioner herein. Whereas, my lord, the defaulter is a principal debtor and her husband.
1 of 22.
My lord, there is the interim stay is required because the garnishee is being directed to attach her salary to an extent of 12,000 rupees every month.
Some surety, some deposit. What is the amount due now? 8 lakhs, huh?
10,65,000 and add, my lord.
How much will you deposit?
She is about to retire. She is the only breadwinner for the family.
Let her deposit 3 lakhs.
1.5 lakhs what is what is the?
No, 3 lakhs. If you're willing to deposit 3 lakhs, I can grant a stay.
I'll get the instructions from the client, my lord.
Then we'll call it whenever you have instructions.
Maybe a week's time may be granted, my lord.
No, list on. At the request of the Learned Council for the petitioner, list on 20th, huh? 20th September 2022.
Please, my lord.
What is suit for? Who are you?
Proceedings are taking and not. And we will come out to the employer. I said, there is a regular perspective we need to. And in the regular perspective, we will model.
Who are the parties in the regular? Who are the parties in the RFA?
Respondent number 7.
Respondent number? Narayana. The list
There is a regular perspective pending. Which I am also at party.
Only the RFA.
Last year we had. There are more than 50. And the RFA does not pertain to the law. Therefore, now we bring those documents. Right, the amendment application of the along with the proceeding. And respect to the receipt of the relevant document. Along with the amendment application.
CH-22. Well, original. Let me see what, let me understand what is this RFA. You have a copy of that? Yes. Now, was it not the subject part of that suit? Let us see, let us see whether this property was a subject part of the earlier proceedings before the Madras High Court or whatever. That is cancelled. Whether these two receivers. But these two receivers must have been sharers. No, they were appointed by the courts amongst the sharers. Outside the array of parties.
if then they are appointed only to see if there are any income tax dues. They have been appointed to not generate the property, collect the amount from their house for part of the income tax. Now they have not moved their rate. The parties to the suit have not moved their
Yes,
rate.
Mr. If that is a fact, how is
This
the?
government is and by writing all certificates you are rewriting the state. And I bring it in multiple this 4 months thereafter, an affidavit is given saying that we had a difficulty, we have cancelled the earlier registered power company, other registered power company cancellation. An affidavit is taken as by the earlier GP. Now, how could these things be components will not have no right at all in homes? If we have to get over this happening, then can the receivers have to be then they will not come up challenges. And to get over this,
This application. But application date will be rejected. On the ground, the problem was not be taken into I cannot report this out of the
No, but how were you, no, were you appointed as receivers in the suit? With the Madras High?
Even before the Supreme Court, and depending the proceedings as receivers, they do not object.
Let it be. But please tell us whether you were receivers in the suit, appointed as receivers in the suit, whether the suit is disposed of.
Suit has been disposed of, and subsequent to the disposal of the suit, additional documents are disclosed that the family member was also confirmed. Powers given by the particular receivership and authorized him to continue with that. The suit was also applied to compromise to court to pay substantial amount to the family members. That is also.
Where is there any transfer deed in your name? Is there any transfer in your name?
So far as this particular property is concerned, looking at the receiver before the High Court, what said, he must clear the income tax. Once it is clear, rest of the property is in the income. There was an interim order to that effect. In response to that particular interim order, I cleared the income tax dues.
Not from your pocket. Not from your pocket.
Properties were situated in Bangalore City and Kolar. But the order of the Honorable High Court would say that once the property is not free of charge, the receivers can proceed and enjoy the property and sell away the property in favor of third party because they are not being given any fee by the court. The incentive by the court was to take these properties. Whatever is the due to the income tax department will check it. Whatever properties that are there available in the family after clearing the income tax due, you can have those properties that is ordered to the
How can the court confer title? How can the court transfer title of a property which it does not own?
And even today, even before the almost Supreme Court, the tenant's application maintained against me. Not in respect of the very same property. They claim that they are tenants under me. In respect of survey number 121 property.
You can attack the compromise provided number 1. This property must be the subject matter of that suit, number 1. Number 2, you should have something to show that you are a title holder of this property. Yaradu torsi.
All those documents are before the hand.
The office is directed to list an application filed by the petitioner herein for amendment. Amendment filed on 23rd of August. 3rd of August 2020. This down date put yaad on the 26th. Interim order granted earlier. Interim order status quo granted earlier. It's the next state of law. The case Nagaraj Rao.
I am for the petition, my lords. I am for the petitions. I challenge the order dated 18/3/22. The trial court has directed to pay court fee on the market value of the property in a partition suit. Impugned order at page 20, my lord. Impugned order at page 20. In a suit for partition, the properties are involved or the agriculture lands, but there is a release deed. The court directed to pay the court fee on the release deed. Consideration shown in the release deed. Your Honor, kindly see, all the properties are agriculture lands is accessible under section 7 of the Karnataka Court Fee and Suit Valuation Act, 1.5 times. And the court cannot direct to pay the entire court fee under section 38 in a partition suit. That is under challenge. And further, your Lordship may kindly see this release deed dated 13/12/2015, which is came into force, which is came into effect after the amendment. Therefore, it is a void document. Section 6 is the amended act clearly indicates that any document came into existence on or before the appointed date, that is 2012-2004. So void document, I did not challenge it even. Therefore, I sought for a stay of that order. Court has not issued notice to the other side, but raise an objections and first an order.
Where is the order?
Order at page 20, my lord. Please therefore, as per section 38 of the Karnataka Court Fee and Suit Valuation Act, the plaintiff 1 and 3 required to pay the court fee on the basis of the consideration stated in the release deed, which was received by the plaintiff 1 to 3. In the present case, the plaintiff 1 to 3 have challenged the release deed on 13 on date of the day as void as null and void. When the plaintiff 1 to 3 have parties to the aforesaid release deed, they have to pay the court fee and the market value on section 38 of the act. Therefore, they are not entitled to cancel the aforesaid release deed. Hence, the plaintiff 1 to 3 are directed to pay the court fee on 1 crore. That is.
All the properties are agriculture properties.
All properties are agriculture. Client have produced the client before the court. That is page 22, copy of the client. Schedule starts at
notice petition. Thank you for the petitioners directed to serve the learned HCGP till the next date of hearing, the order on court fee dated 18/3/2022 passed by the trial court. Voice number 552 of 2022.
emergency method.
Please serve a copy to the HCGP.
Okay. Set up.
Since then, the court has been hearing the matter, therefore, it is like report said that within 6 months' time, to serve for my case is that more than 6 years, still there is no right inside. That is why I am saying that there is nothing to be heard in the matter because statement petition next that can't be decided by the court.
Petition is filed for a direction to the 16th Additional City Civil Administration Judge Bengaluru to expedite the decision in EP number 132 of 2010. The suit invoice number 269 of 2003 was filed for recovery of a sum of rupees 269 which was decreed on 12th March 2009. An execution petition was filed in EP number 132 of 2010, which is not concluded till date. Therefore, it is necessary to direct the executing court to dispose of the execution petition at their earliest. Consequently, by dispensing notice to the respondent, this writ petition is allowed, and the executing court is directed to dispose of EP number 132 of 2010 within a period of 4 months from the date of receipt of a certificate, a period of 6 months from the date of receipt of a certificate copy of the order. It's looking out. Delhi Ashok Bartane. The petitioner, who was the plaintiff in OS number 6284 of 2009 on the file of the City Civil Court, Bangalore, is aggrieved by the order dated 8th December 2017, by which, an agreement, a lease agreement, by which, a lease agreement, a franchisee agreement, agreement, and by which exhibits P12, P5, and P9 were impounded and referred. Was it referred? Was impounded for collection of duty and penalty. Next para. The suit in OS number 6284 of 2009 was filed for perpetual injunction in respect of a commercial premises. In respect of a commercial premises. The defendant was claimed to be the owner of the suit property, which was rented out. Defendants were the owners of the suit property, which was rented out to the plaintiff, who in turn had entered into a franchise agreement to conduct business in the suit premises. Stop. The defendant claimed that the plaintiff had sublet the premises and therefore, plaintiff was not entitled to any relief. They also claimed that the plaintiff had entered into a franchise agreement beyond the lease period and that he was a beneficiary of a larger income from the premises from the said franchise agreement. Stop. Next para. The suit was set down for trial. The plaintiff was examined to mark the lease deed as well as the franchise agreement and certain receipts, which were found to be insufficiently stamped. Hence, the court, exercising power under section 34 of the Karnataka Stamps Act 1957, impounded the said documents for collection of duty and penalty. Being agreed with the said order, the present petition is filed. The learned counsel for the petitioner submitted that the learned counsel for the plaintiff submitted that the lease agreement dated 3/6/2001, bracket exhibit P1, was a term of 3 years, 11 months, was for a period of 11 months from the date of the agreement, and that the rate of rent agreed upon was ₹5,000 per month. We submitted that the court was bound to consider the provisions of the Karnataka Stamp Act 1957 as was applicable as it prevailed on 3/6/2001 and calculate this proper stamp duty and collect and the penalty in view of the judgment of the division bench of this court in so on so on. Stop. We submitted that even if the document was impounded, unless there was an agreement to the contrary, it was the lessee who was supposed to pay the rent. Stamp Act. Yeah, section 14 or 38. 30. No, section 30, who has to tenant ಕೊಡಬೇಕು. You are the tenant. Plaintiff ಪ್ರಸಾದ್ ಅಂತಿದ್ದೆ, ನೀವು ಪ್ರಸಾದ್ ಅಂತ ಇದ್ದೀರಾ? We submitted that the franchise agreement ಮೇಲೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ? How much is paid on the franchise? ₹100. Franchise agreement ಮೇಲೆ ಎಷ್ಟು ಕೊಡಬೇಕು? ಎಲ್ಲಿದೆ? Not provided. Article 5 ಅಲ್ಲೇ ಬರುತ್ತಲ್ಲ ಅದನ್ನು. ಅದು Article 5 ಅಲ್ಲೇ ಬರಬೇಕಲ್ಲ. Not otherwise provided for ₹200. Mortgage, depository, contract fees relating to advertisement, Article 5. Article 5. Any other case? No, that is. Please come to J, Article J, Sub-Article J. Any other case, ₹200. Because 100 ಅಂತ ಇತ್ತಾ? J. We submitted that the sum of ₹100 was paid on the franchisee agreement, exhibit P9, which was sufficient, and therefore, the order passed by the trial court deserves interference. The learned counsel for the response on the other hand submitted that under the lease agreement, the rent agreed upon was rupees 5,000 per month, and an advance deposit of rupees 5 lakhs was paid, and therefore, the rent as well as the deposit has to be considered. The annual rent as well as the deposit has to be considered while calculating the stamp duty. He also submitted that the franchise agreement was for a period of 5 years, and the possession of the property in question was delivered to the principal of the plaintiff, and therefore, the amount covered under the agreement, amount of agency fees payable under the said franchise agreement has to be considered for the purpose of calculating the proper stamp duty. Next para. I have produced the documents at Exhibit P1 and P9. Exhibit P1 is a lease agreement for a lease agreement in respect of the source property, which was for a period of 11 months from the date of the agreement. Full stop. Therefore, the relevant provision determining the stamp duty on such agreement is Article 31, Clause A, 31A, small 1, small Roman I, which specifies the rate of stamp duty as the same duty as a bond for the whole amount payable or deliverable under such lease. Bond 12, the stamp duty payable on a bond is rupees 5 for every 100 or part thereof. Is 5 rupees is 50 rupees for every 1,000. 50 rupees for the first 1,000 rupees. And rupees 25 for every 500 rupees or part thereof in excess of 1,000. In the present case, full stop. It is relevant to note that Article 30 did not take into account the advance received by the lessor for the purpose of stamp duty. Therefore, it is only the annual rent, it is only the rent for the tenure that has to be taken into consideration for the purpose of determining the stamp duty. If that be so, the total rent agreed to be paid under Exhibit P1 is a sum of rupees 55,000. Consequently, the stamp duty payable on Exhibit P1 was a sum of rupees 50 on the first 1,000 rupees and rupees 25 for every 500 rupees exceeding rupees 1,000. Therefore, the total rent payable would be, the total stamp duty payable would be rupees 2,750 on exhibit P1. Applying the law laid down by a division bench of this court in Digambar Varti, the plaintiff was liable to pay. Expected was liable to pay rupees 2,200. Was liable to pay the deficit stamp duty of rupees 2,200 and penalty of the sum of rupees 22,000. Full stop. Therefore, the trial court ought to have collected the duty and penalty of a sum of rupees 24,200 and make appropriate endorsements on exhibit P1 and admit the same in evidence, as the document did not require compulsory registration. Stop. Insofar as the franchisee agreement at exhibit P9 is concerned, the same was drawn on 1st November 2007. 2007, and as per the applicable entries in the Stamp Act, only a sum of rupees 100 was payable as a stamp duty on such document, which is done in the present case. Therefore, the defendant, therefore the trial court ought to have allowed this stock, ought not to have impounded exhibit P9. Stop. In that way of the matter, this expedition is allowed. The impugned order is expedition is disposed of, directing the plaintiff to pay a sum of rupees 24,200 as the deficit, stamp duty, and penalty on exhibit P1. Stop. The trial court is directed not to insist upon payment of any stamp duty insofar as exhibit P9 is concerned. P9 is concerned and marked and P9 is concerned. Likewise, exhibit P2 to P4. P2 to P4 are the receipts under which under which additional advance is paid by the plaintiff to the defendant. Yavagadu? Yavaga 2001, 2002, 2002, 2002, which are all executed in the year 2001, 2000, and 2002. During which time, the advance, the earnest money paid under the lease agreement was not taken into consideration for the purpose of calculating the stamp duty. Hence, they said documents. Hence, no stamp duty shall be insisted on the said documents. The petition stands disposed of on the above terms. We make appropriate corrections. Mr. M. Srinivasa. Yeah. What does it say? Notice, if you want to go through, please go through. Then you have to go before the civil court and do whatever you want. No copy, sir. Please have a look at it. Password. Photograph only. Take a photograph, print it yourself. Photo. Please permit them to take photographs. Sorry, sir. Pass over, I know. Want it to be passed over. Like if you want it to be passed over, I'll pass it over. Otherwise, you please look into it. Inondina fix one. The learned HCGP has placed on record the file as directed with this court. The HCGP has placed on record the records received as noticed by this court on 17/6/2022. The counsel for the petitioner seeks petitioner in WP number 42777/2012 seeks time to verify the same and make submissions. List on next week ಕೇಳಬೇಡಿ ಸರ್ ಇಲ್ಲ ಇವತ್ತು ಮಾಡಿ ಇಲ್ಲ ಒಂದು ಬೇರೆ ಡೇಟ್ ತಗೊಳ್ಳಿ ಯಾವ ಡೇಟ್ ಕೊಡ್ರಿ ನೀವೇ 23rd. Yes. Yes, madam. Yes. No, madam, you should argue no extension. 2015, no extension. Part one. ಇದು affidavit ಇದು. Affidavit. Additional affidavit. Please ask Mr. Balkrishna Shastri, he will help you. ಯಾರು ಹೇಳಿ ಅವರು? What did you hear? ಏನ್ ಕೇಳಿಸ್ಕೊಂಡ್ರಿ? ಯಾರು? Ask whom? ಸರಿ ಕೇಳಿಸ್ಲಿಲ್ವಾ? ಮತ್ತೆ yes ಮಾತಾಡ ಅಂದ್ರೆ? Please ask Mr. Senior Counsel, Mr. Balkrishna Shastri, who is sitting behind you for some guidance. Filing of ಯಾವ್ದೊಂದು affidavit ಹಾಕ್ತಾರೆ ಮತ್ತೆ ಇನ್ನೊಂದು additional affidavit. There is no end to it. They keep on filing affidavits. Whether such filing of such an affidavit is permissible or not. Also, please ask for guidance. He will guide you. Yes, next. No.
The execution case number 286. Before the executive court, the petitioner and radio were working on how to decide position to do that. But he was only working as how being done with that. The Royan and not that service. This mistake is so. It was working as a housemate at Partition. But he has suffered a low fracture. And he has not diabetes in the areas. That was waste to me. And application came to find one day. I filed the applications in the court CT. Permission to file appeal as an indigent person because I have not. That is being implemented. Therefore, the state is the CT is decided. So it rejected that application, and then he is later restored. That's why. So, yes, those orders are issuing the arrest warrant against the judgment order. Without conduct in India, it's very religious. The law and order is the focus on the minimum is not the same, which now is divided into as the next year. So the report was to fly the order, as an illegal person.
The problem is so long as you are solvent. So long as you are solvent.
Neither I am solvent nor I am anything. That is my section. I have workers, I have gold, I have silver. I am practically nothing but living except this. There is not a specific.
No, but the problem is indigent person at the permit madadre, payment of stamp duty is postponed astray, not dispensed.
Unless the charging section, probably the executive corporation arrest warrant. Arrest warrant could be sure as the judgment debtor needs the jurisdiction of the son, where the judgment debtor alienates the property, but the jurisdiction of the court not provided. But not being having sufficient means, willfully, not being created. These are the things.
What are the other means? Was the other means resorted to attachment of movable? So adu madilva. ಅದೆಲ್ಲ ಮಾಡ್ದಂಗೆ ಹಿಂಗ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ. Straight away ಹೆಂಗ್ ಮಾಡಕ್ ಬರುತ್ತೆ ಅಂತ ಕೇಳಿ. How can they issue a warrant straight away without exhausting the other methods? In fact, they have sought for attachment and sale of movables.
This is my identified
Settlement here chances idea. Settlement.
These are two friends. He is also a superior to me. Both of them are Telecast.
Interest biddಕ್ಕೆ ಏನೋ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡೋಣ ರಮೇಶ್ ಕುಮಾರ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿ ಪಾಪ ಅವ್ರು ದುಡ್ಡು ಕೊಟ್ಟರೆ ದುಡ್ಡು ವಾಪಸ್ ಕೊಡಿ ಸರ್. This is a country where the son is liable to clear the father's debts. ಅಪ್ಪ ಮಾಡಿದ ಸಾಲನ ಮಗ ತೀರಿಸುವಂತ ದೇಶ ಇದು. ಏನೋ ಕುಡಿಯಕ್ಕೋ ಪಡಿಯಕ್ಕೋ ಏನಕ್ಕೋ ಒಟ್ಟು ದುಡ್ಡು ಇಸ್ಕೊಂಡು ಕುಡಿದು ಬಿಟ್ಟಿದ್ದೀರಾ, ಕೊಡಿ ಅಷ್ಟೇ ವಾಪಸ್. ನಿಮ್ ದುಡ್ಡಲ್ಲಿ ನೀವು ಕುಡಿಬೇಕಾಗಿತ್ತು, ಕಂಡೋರ್ ದುಡ್ಡಲ್ಲಿ ನೀವು ಕುಡಿಯೋದು ಎಂತದ್ದು? ರಮೇಶ್ ಕುಮಾರ್ Stay idea. How old is he?
Please don't talk slightly.
ಸ್ವಲ್ಪ ದಿನ ಇದ್ನು. We'll keep it pending. We'll keep. We want it to be pending for some more time so that.
That's right. It's right now. Both of us are doing that.
There's no representation for the respondent number one. List on. Is Pradeep PV appointment of Mr. Pradeep DV. Yes, what is this case? Really, case here. You're not well. Huh? Hello, if you have difficulty to argue, we'll adjourn it to some other. At the request of the Council for Petition and Response. ಹೆಗ್ಡೆ ಹೂಡ್ಲೆ ಮನೆ ಪಾಸು.
I'm appealing for the 49, my lord.
48.
Sorry.
ನೀವಿದ್ದೀರಾ ಭಟ್ರೆ? NOC ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು? ಹೇಳಿ. KS Nataraj, Harsha D Joshi, Ramanjaneya, password.
49.
I'm appealing for the appellant, my lord.
Bill Prasad Place. Yes, madam.
My lord, this is a case filed by the appellant for partition and declaration of a share, my lord. Your lordship may kindly see the plaintiff is at page 28.
28.
28, my lord. And the prayer is in page 32, my lord.
Yes.
She is asking in the last, your lordship may kindly see, preliminary decree for partition declaring the plaintiff is entitled for 21 right, title and interest in the plain scheduled property, direct a division of the plain scheduled property by metes and bounds, taking into consideration the good soil and the bad soil, and divide the property and allot 2/21 of such share to the plaintiff and cost. This is the plaint filed by the appellant, my lord. During the course of cross-examination, my lord, she is the child. The father of this appellant has first wife died, and there are children out of the first wife, and the appellant is also the child of the other wife, Your Honor, my lord. In this case, what has happened, my lord? While during the cross-examination, my lord, mother was not keeping well, and she was sick, so she was running around in the hospital. So during that time, it was posted for cross-examination, and she was not in a condition to appear. So the court has come on the position that if she doesn't appear, it will be dismissed and closed. For that reason, she appeared and she participated in the cross-examination, my lord. During cross-examination,
mother is which defendant?
My lord.
Mother is which defendant?
Mother is the defendant. She is the appellant, is the daughter of the first wife. Sorry, the second wife. The first defendant and fourth, fifth, sixth are from the first wife. So as per the Indian Succession Act, she is entitled for a share along with her brothers.
Plaintiff before the trial court is the daughter of the second wife.
Second wife. Second wife, my lord, the first wife died. Then the father married. So legally wedded wife. She's also a legitimate child, my lord.
Yes.
That's an admitted fact before the trial court also.
Who are the defendants? Who are the defendants?
Defendants are the brother of the appellant from the first mother. That is defendant number 1 and defendant number 4, 6, 5 and 6.
Defendant number 1, 4, 5
and 6 from the first mother.
5 and 6. Yes, who are the defendants 2 and 3?
2 is her sister and
Sister Allah, Renault and Mr.
sorry,
Renault.
sorry. That is 2 is Mrs. Weber Perez. Mrs.
No.
Weber Perez.
That is defendant number 3.
Yes, Renault Matthews is the defendant number 2.
Correct. Who is he?
He's the brother.
He is the brother.
Brother.
1, 2, 4, 5, 6.
I'm sorry again. Respondent 1 and 3. Your lordship gets 1 is I'll just take the plaint, my lord, because it's overlapping in the appeal. So I'll just take the plaint and I'll submit. The first one that your lordship may kindly see page 28, Annexure B.
Yes.
That is that Mrs. Maxie Matthews is the first defendant.
Correct. Who is she?
This is the daughter of the first wife.
She is a stepsister.
Stepsister.
Defendant number 1. What about defendant number 2?
Defendant number 2 is appellant's own brother.
Own brother.
Own brother. Then defendant number 3. Defendant number 3 also is the sister of the appellant. Then defendant number 4 and 5 and 6 and 7. They are the step brothers and sisters.
Yes.
Yes, Your Honor. Now, Your Honor may kindly see the very petition has been filed disputing the will. That is, she has pleaded in her plaint. The very plaint has been filed against the being intestate. That is, the father has died intestate and share has to be given to all the children. That is the case she has filed. During the cross-examination, when she was not exactly in depression, but she was running around with her mother's illness and hospitalization, it was posted for cross-examination. During cross-examination, one document was shown to her and she has admitted the document, and it is marked as D1 document, which is nothing but a probate, which is a probate document, which she has denied actually, but she filed application 6 and 7 IA, recalling that admission, because it was only a signature was shown to her. Your lordship may kindly see Annexure G, page 63. This is the exhibit D1 which was marked, and only the signature was shown to her. So she did not have an occasion to see the entire document. So during the cross-examination, she has admitted. Then she has filed application. Your lordship may kindly see the IA filed by her. I have produced the order sheet, and then I will take your lordship to the IA. The order sheet, if your lordship may kindly see on page 22. This is what I have challenged before this honorable court. Page 22 is the order where she files IA 7 and IA 8.
Yes.
And which was allowed with cost of 1,000 rupees, which was received by the other side also for reopening the stage and recalling the admission made by her, because her suit itself is pertaining to the death of the father intestate. Your lordship may kindly see the IA produced by me. It's Annexure K. Annexure K, page 82. This is for reopening the stage, your lordship. And IA 8 is the next. Affidavits is followed in the 83 page, which is IA 8 is in page 85, your lordship. This is for recalling the PW1 for further examination. This both the IAs as per page 22 has been recalled. Allowed, and the cost was imposed, and which was taken.
Can we read this order 7, 12, 20?
I will read it. I'll read page 22. Page Learned counsel for the plaintiff files an application under order 151 of CPC, and the prayer of the plaintiff in IA 8 also filed application under 151.
Where are we reading?
Page 22, Your Lordship. The order. Your Lordship wants me the detailed order.
Yeah, detailed.
Yes, I'll go to the detailed order. Your Lordship, I'm sorry. I'll go to the detailed order. That is the IA page 23, my lord.
Yes.
Yes, my lord. This is an application filed by the defendant under section 151 of the CPC. The facts in brief of the memorandum of facts annexed to the application of the defendant is the plaintiff has filed a suit for partition and separate possession of legitimate share of the plaintiff in the suit scheduled property on the ground that her father died intestate. In the written statement, defendant has contended that his father has executed a last will and testament dated 18/2/1975, which was probated before the Honorable High Court of Mumbai. And during the cross-examination of PW1, these facts has been admitted and also admitted the documents which was probated before the court. The said evidence of PW1 was recorded on 24/9/2013. After a lapse of 2 months, plaintiff has filed application to provide an opportunity to put forth her further examination, and while filing further cross-examination, the admission made in the cross-examination of PW1 was taken away, and in order to overcome the admission of further chief examination, affidavit is filed, and as per section 136 to 138 of Indian Evidence Act, it is clear that once the cross-examination is made, there will be no scope for the re-examination, and further chief examination can be allowed.
Cannot be allowed.
My lord?
Cannot be allowed.
Cannot be allowed. In order to take away the admission of the cross-examination of PW1, the further chief examination affidavit is filed as per para 2 to 5 of the chief examination, which cannot be allowed. Hence, prayed to reject the further chief examination filed by the plaintiff. The brief averments of the objections filed by the plaintiff is that plaintiff has sought for further chief examination of PW1, and the said application was allowed by recalling PW1 on the cost, and the cost was received by the defendant and admitted that the order of the recalled and reopening of the case of the plaintiff. Now, when the further chief examination is filed, the present application is filed to reject the same, which is not maintainable. PW1 was not in good state of mind during her cross-examination by the defendant. Hence, to clarify the same, present further chief examination is filed. The law does not prohibit to depose further chief examination. If further chief examination is filed, it is subject to cross-examination of the other side. The further chief examination affidavit do not contain takeaway admissions already made by PW1 in our cross-examination. As such, prayer to allow the further chief examination of the plaintiff and to expunge the further chief examination do not arise at all. Hence, pray to reject the application with cost. Heard the arguments on both the side. The point that would arrive for consideration, arrive for determination is whether the defendant made out sufficient grounds to allow the present application. My finding to the above point is affirmative for the following reasons. In the present application, the defendant has sought to reject the further chief examination of PW1 filed by way of an affidavit on the ground that while cross-examining PW1 by defense counsel on 24/9/2013, PW1 has admitted with regard to probate and made before the Court of Mumbai with regard to testamentary disposition of her father. And now, in order to take away those admissions, the present chief examination affidavit is filed. And in para 2 to 5 of the said chief examination, there is a recital with regard to take away the admission made by the PW1 in our cross-examination. Hence, the said portion of the chief examination has to be expunged. On the other hand, the learned counsel for the plaintiff contended that while cross-examining PW1, she was not in a good state of mind. As such, she could not be able to depose properly. As such, to clarify the same, the present further cross-examination affidavit is filed on the permission granted by the court by allowing the application for reopen and recall of the PW1. On the perusal of the further chief examination affidavit of PW1 herein are contended by the defense counsel in para 2 to 5. There are recitals with regard to take away the admission of PW1 in cross-examination of the defense counsel. That being so, for taking away the admission of cross-examination of PW1, no further chief examination can be allowed. If any chief examination is left out earlier, can be incorporated by an affidavit by PW1, which will be subjected to cross-examination. Hence, the further chief examination affidavit filed by PW1 is liable to be rejected with the direction to file a fresh further chief examination. Accordingly, I proceed to pass the following order. IA 9 filed by the defendant under section 150 on CPC is hereby allowed. Consequently, the further chief examination affidavit filed by the plaintiff is rejected with the direction to file fresh further chief examination affidavit if it is required.
Yes.
My lord, my submission is my very plaint is on the fact that I'm disputing the will and I'm not. I'm submitting that father died interstate and I'm entitled.
Signature is found on the probate. If your signature is found on the probate issued by the High Court of Bombay,
Yes.
and that you admit your signature.
That signature, that is what she is submitting, that it is not served on her at all. So it is not her signature, is her contention.
Then you establish that.
That we will be establishing in our plaint only, which we have filed before the trial court. Once I'm creating a doubt on the will, it is for the.
Madam, once if you have established or once you have admitted your signature,
yes,
on the probate, you cannot resile from it, isn't it? You cannot say that is not your signature.
My lord, that is the case of the plaintiff. Your lordship may kindly see her mother died. She was in the hospital when she was running around, and she requested also every time that during that period she will not be able to lead the evidence.
What is the cross-examination on this probate? How you are confronted with this document?
This is still, my lord, it is marked as.
Where is the evidence? Where is the evidence?
That evidence I have to produce. In this marked document I produced already, which she has disputed the signature. And even the address is.
Where is the evidence where you admit this probate?
To that extent.
Page 50. Page 50 evidence ideyalla.
50. That is the examination in chief of the appellant.
Cross-examination is also there.
Cross-examination lab.
No, dear. Please read. Page 56.
That. I require assistance from my colleague. Can I take that, my lord?
Yes, why not? Please go ahead.
I'll just request, my lord. Where the court? Where the court? I'll read in the beginning part of it, your lordship. Typed copy is in page 60, your lordship.
Yes.
Page 60.
Yes, ma'am.
Admissions for the. My lord, I'm taking the assist of my colleague, Advocate Narayan Bhatt.
Yes.
Read this. Beginning in the new.
ಸಾಕ್ಷಿಯನ್ನು ಪುನಃ ಕರೆಸಿ ಪ್ರಮಾಣ ವಚನ ಬೋಧಿಸಲಾಯಿತು. ಪಾಟಿ ಸವಾಲು. ಪ್ರತಿವಾದಿ 2-4 ಪರ ವಕೀಲರಾದ ಎಂಪಿಎಸ್ ರವರಿಂದ. ನನ್ನ ತಂದೆಯವರು ಇಂಡಿಯನ್ ಏರ್ಲೈನ್ಸ್ ನಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರೆಂದು ಹೇಳುವುದು ಸರಿ. ನನ್ನ ತಂದೆಯವರು ಈ ಕೀರ್ತಿ ಕೋಆಪರೇಟಿವ್ ಹೌಸಿಂಗ್ ಸೊಸೈಟಿ ಬ್ಲಾಕ್ B6 2ನೇ ಮಹಡಿ ಕಲೀನಾ ಮುಂಬಯಿಯಲ್ಲಿ ವಾಸವಾಗಿದ್ದಾರೆಂದರೂ ಹೇಳುವುದು ಸರಿ. ಸಾಕ್ಷಿಗೆ ಒಂದು ದಾಖಲೆಯನ್ನು ತೋರಿಸಿ ಅದರಲ್ಲಿರುವ ಸಹಿಯನ್ನು ತೋರಿಸಿದಾಗ ಅದರಲ್ಲಿ ಸಹಿ ತನ್ನದ್ದು ಎಂದು ಒಪ್ಪಿಕೊಂಡದ್ದು, ಅದನ್ನು ನೀಡಿ1 ಎಂದು, ಸಾಕ್ಷಿಯ ಸಹಿಯನ್ನು ನೀಡಿ1 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ನನ್ನ ತಂದೆಯವರಿಗೆ ಮುಂಬೈಯಲ್ಲಿ ಒಂದು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಇತ್ತು ಎಂದು ಹೇಳುವುದು ಸರಿ. ನನ್ನ ತಂದೆಯವರ ನಿಧನದ ನಂತರ ಮುಂಬೈಯಲ್ಲಿರುವ ಅಪಾರ್ಟ್ಮೆಂಟ್ ನನ್ನ ತಾಯಿಗೆ ಸೇರಿರುತ್ತದೆ. ಪಿಟಿಷನ್ ನಂಬರ್ 187 of 91 ಅನ್ನು ನನ್ನ ತಾಯಿಯವರು ಮುಂಬಯಿಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಲ್ಲಿಸಿದ್ದರೆಂದು ಹೇಳುವುದು ಸರಿ. ಸದ್ರಿ ದಾಖಲೆಯನ್ನು ಸಾಕ್ಷಿಗೆ ತೋರಿಸಿ ಕೇಳಿದಾಗ ಹೌದೆಂದು ಒಪ್ಪಿಕೊಂಡಿದ್ದು ಅದನ್ನು ನಿಶಾನೆ ಡಿ ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ನಿಶಾನೆ ಡಿ 2ರಲ್ಲಿರುವ ಒಂದು ದಾಖಲೆಯನ್ನು ತೋರಿಸಿ ಸಾಕ್ಷಿಗೆ ಹೇಳಿ ಸದ್ರಿ ದಾಖಲೆ ಆಧಾರದ ಮೇಲೆ ಆಕೆಯ ತಾಯಿ ಮುಂಬೈಯಲ್ಲಿರುವ ಅಪಾರ್ಟ್ಮೆಂಟಿನ ಮಾಲೀಕತ್ವಕ್ಕೆ ಕೇಳುತ್ತಿರುತ್ತಾರೆಂದು ಒಪ್ಪಿಕೊಂಡಿದ್ದು ಸದ್ರಿ ದಾಖಲೆಯನ್ನು ನೀಡಿ 2A ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ನೀಡಿ 2A ದಾಖಲೆಯ ಬಗ್ಗೆ ನನ್ನ ಯಾವುದೇ ತಕರಾರು ಇರುವುದಿಲ್ಲ. ನನ್ನ ಅಣ್ಣ ತಮ್ಮಂದಿರು ಈ ದಾವೆಯಲ್ಲಿ ಸಲ್ಲಿಸಿರುವ ಲಿಖಿತ ತಕರಾರುಗಳನ್ನು ನಾನೇನು ಓದಿಸಿ ನೋಡಿ ತಿಳಿದುಕೊಂಡಿರುವುದಿಲ್ಲ. ನನ್ನ ಅಣ್ಣ ತಮ್ಮಂದಿರು ಲಿಖಿತ ತಕರಾರು ಸಲ್ಲಿಸುವಾಗ ಯಾವ ದಾಖಲೆಯನ್ನು ಅವಲಂಬಿಸಿರುತ್ತಾರೆ ಎಂಬ ಬಗ್ಗೆ ನಾನು ತಿಳಿದುಕೊಳ್ಳಲು ಪ್ರಯತ್ನ ಪಟ್ಟಿರುವುದಿಲ್ಲ. ದಾವಾ ಸ್ವತ್ತುಗಳು ನನ್ನ ತಾಯಿಯವರ ಜೀವಿತ ಕಾಲದಲ್ಲಿ ಲೈಫ್ ಎಸ್ಟೇಟ್ ಆಗಿ ಇಟ್ಟುಕೊಳ್ಳುವ ಅಧಿಕಾರ ಮಾತ್ರ ಇತ್ತು ಎಂದು ಹೇಳುವುದು ಸರಿ. ನಿಶಾನೆ P1 ಪ್ರಕಾರ ನಾನು ಮೊದಲ ಬಾರಿಗೆ ದಾವಾ ಸ್ವತ್ತಿನ ಮೇಲೆ ನನಗೆ ಹಕ್ಕಿದೆ ಎಂದು ಪ್ರತಿಪಾದಿಸುತ್ತೇನೆಂದು ಹೇಳುವುದು ಸರಿ. ನನ್ನ ತಂದೆಯವರ ನಿಧನದ ನಂತರ ದಾವಾ ಸ್ವತ್ತಿನಲ್ಲಿ ಸ್ವಾಧೀನದಲ್ಲಿ ನಾನು ಎಂದೂ ಸಹ ಇರಲಿಲ್ಲವೆಂದು ಹೇಳುವುದು ಸರಿ. ದಾವಾ ಸ್ವತ್ತಿನಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ ಮತ್ತು ವಿಸ್ತೀರ್ಣ ನನಗೆ ತಿಳಿದಿರುವುದಿಲ್ಲ. ದಾವಾ ಸ್ವತ್ತಿನ ಚಕ್ಕುಬಂದಿ ಸಹ ನನಗೆ ತಿಳಿದಿರುವುದಿಲ್ಲ. ನಾನು 1989ರಲ್ಲಿ ಮದುವೆಯಾಗಿರುತ್ತೇನೆ. ನಾನು ಮದುವೆಯಾಗುವ ಸಮಯದಲ್ಲಿ ಮುಂಬಯಿಯ ವಿಮಾನ ನಿಲ್ದಾಣದಲ್ಲಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದೆ. ನನ್ನ ಪತ್ನಿ ಸಹ ಮುಂಬಯಿಯ ಒಂದು ವಿಮಾನ ಸಂಸ್ಥೆಯಲ್ಲಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದರು. ನನಗೆ ಒಬ್ಬ ಮಗ ಮತ್ತು ಮಗಳು ಇದ್ದು ಅವರು ಮುಂಬಯಿಯಲ್ಲಿ ವ್ಯಾಸಂಗ ಮಾಡುತ್ತಿರುತ್ತಾರೆ. ನನ್ನ ತಂದೆಯವರು ಮೊದಲ ಒಬ್ಬರನ್ನು ಮದುವೆಯಾಗಿದ್ದು ಆಕೆಯಿಂದ 3ನೇ ಪ್ರತಿವಾದಿ ಹುಟ್ಟಿರುತ್ತಾರೆ. ನನ್ನ ತಂದೆಯವರು ತನ್ನ ಮೊದಲ ಹೆಂಡತಿಯ ನಿಧನದ ಮತ್ತೊಂದು ಮದುವೆಯಾಗಿದ್ದರು. ನನ್ನ ತಂದೆಯವರ ಮೊದಲ ಪತ್ನಿಯಿಂದ ಒಬ್ಬ ಮಗ ಸಹ ಇದ್ದು ಆತನು 2ನೇ ಪ್ರತಿವಾದಿಯಾಗಿರುತ್ತಾರೆ. ಮೊದಲನೆಯ ಪ್ರತಿವಾದಿ ನನ್ನ ತಂದೆಯ 2ನೇ ಪತ್ನಿಯಾಗಿರುತ್ತಾರೆ. ಅವರಿಗೆ 6 ಜನ ಮಕ್ಕಳಿದ್ದು ನನ್ನ ತಂದೆಯವರು ನಿಧನ ಹೊಂದುವವರೆಗೂ ಆರೋಗ್ಯದಿಂದ ಇದ್ದು ಅವರ ಮಾನಸಿಕ ಸ್ಥಿತಿ ಚೆನ್ನಾಗಿದ್ದು ಎಂದು ಹೇಳುವುದು ಸರಿ. ಮುಂದುವರಿದು ತನ್ನ ತಂದೆಯವರು ತನ್ನ 65ನೇ ವಯಸ್ಸಿಂದ ಮರೆಯುವ ಕಾಯಿಲೆಯಿಂದ ನರಳುತ್ತಿದ್ದರೆಂದು ನುಡಿದಿರುತ್ತಾರೆ. ನನ್ನ ತಂದೆಯವರು 1978ರವರೆಗೆ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದುದು ಅಲ್ಲಿಯವರೆಗೂ ಅವರ ಆರೋಗ್ಯ ಮತ್ತು ಮಾನಸಿಕ ಸ್ಥಿತಿ ಚೆನ್ನಾಗಿತ್ತು. ನನ್ನ ಅಣ್ಣ ತಮ್ಮಂದಿರ ನಡುವೆ ದಾವಾ ಸ್ವತ್ತನ್ನು ವಿಭಾಗ ಮಾಡಿಕೊಳ್ಳುವ ವಿಚಾರವಾಗಿ ಯಾವುದೇ ತಕರಾರು ಇದ್ದಿತ್ತೋ ಇಲ್ಲವೋ ನನಗೆ ಹೇಳಲು ಬರುವುದಿಲ್ಲ. ಈ ಕೇಸಿನ 5ನೇ ಪ್ರತಿವಾದಿಯ ಜೊತೆ ನನ್ನ ಕುಟುಂಬದ ಸಂಬಂಧ ಚೆನ್ನಾಗಿಯೇ ಇರುತ್ತದೆ. ನಾನು 2ನೇ ಮತ್ತು 4ನೇ ಪ್ರತಿವಾದಿಯೊಂದಿಗೆ ಚೆನ್ನಾಗಿರುತ್ತೇನೆ. ನಾನು ಪ್ರತಿವಾದಿಗಳಾದ 2, 4, 5ಗಳ ಜೊತೆ ಸಹ ಚೆನ್ನಾಗಿರುತ್ತೇನೆ. ನಾನು ಎಲ್ಲ ಪ್ರತಿವಾದಿಯೊಂದಿಗೆ ಚೆನ್ನಾಗಿರುತ್ತೇನೆ. ನನ್ನ ನೋಟಿಸ್ ನಿಶಾನೆ P1ಕ್ಕೆ ಪ್ರತಿವಾದಿಗಳು 2 ಮತ್ತು 4ರವರು ನಿಶಾನೆ P2 ಪ್ರಕಾರ ಪ್ರತ್ಯುತ್ತರ ನೀಡಿರುತ್ತಾರೆಂದು ಹೇಳುವುದು ಸರಿ. ನಿಶಾನೆ P7 ದಾಖಲೆಯನ್ನು ನಾನು 2007ರಲ್ಲಿ ಮಂಗಳೂರಿಗೆ ಬಂದಾಗ ಪಡೆದುಕೊಂಡಿದ್ದೆನು. ದಾವಾ ಸ್ವತ್ತಿನಲ್ಲಿ ನನಗೆ ಯಾವುದೇ ಹಕ್ಕು ಮತ್ತು ಸ್ವಾಧೀನ ಇರುವುದಿಲ್ಲವೆಂದು ತಿಳಿದಿದ್ದರೂ ಸಹ ನಾನು ಈ ಒಂದು ಸುಳ್ಳು ದಾವೆಯನ್ನು ಹೂಡಿರುತ್ತೇನೆಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ. ದಾವಾ ಸ್ವತ್ತಿನ ಮೇಲೆ ಹಕ್ಕಿರುವ ಪ್ರತಿವಾದಿಗಳು 2, 4 ಮತ್ತು ಇತರ ಸಹೋದರ ವಿರುದ್ಧ ನಾನು ಸುಳ್ಳು ದಾವೆಯನ್ನು ಹೂಡಿರುತ್ತೇನೆಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ. ಪ್ರತಿವಾದಿಗಳು 2 ಮತ್ತು 4ರವರು 1ನೇ ಪ್ರತಿವಾದಿಯನ್ನು ನೋಡಿಕೊಳ್ಳುತ್ತಿದ್ದಾರೆಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ. ಸಾಕ್ಷಿ ಮುಂದುವರಿದು ನಾನು ಮತ್ತು ಇತರ ಪ್ರತಿವಾದಿಗಳೆಲ್ಲರೂ ಸೇರಿ ನೋಡಿಕೊಳ್ಳುತ್ತಿದ್ದೇವೆಂದು ನುಡಿದಿರುತ್ತಾರೆ. ಪಾಟಿ ಸವಾಲ್. ಶ್ರೀ KTK ವಕೀಲರು ಗೈರು ಹಾಜರಿದ್ದು ಪಾಟಿ ಸವಾಲಿಲ್ಲವೆಂದು ತೆಗೆದುಕೊಳ್ಳಲಿ. ನನ್ನ ಹೇಳಿಕೆ ಮೇಲೆ ತೆರೆದ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಬೆರಳಚ್ಚು ಮಾಡಲಾಯಿತು.
So therefore, if you admitted this affidavit or statement made before the Bombay High Court.
My lord, that is my case, that it is not my signature, or I have not even been served with that notice. The address is also wrong, which is in the petition, which I produced.
You prove it.
That in my further evidence,
You can't take back your admission. You can't take back your admission of this probate document.
My lord, may I rely on one judgment, my lord? Your lordship may kindly see reported in, my lord, 2011 11 SCC 275, that is KK Veluswamy versus Palani Swamy. In this case, my lord, the Honorable Supreme Court has held that I have narrated it in my grounds, your lordship may kindly see page 10, my lord.
Yes.
Para 9, your lordship may kindly see. It was held that in the interest of justice and to prevent abuse process of law, the trial court ought to have considered whether it is necessary to reopen the evidence, and if so, to what, in what manner and to what extent further evidence should be permitted in exercise of power under 151 of the CPC of the code. My lord, in this case, the very case what I have filed itself is stating that it is an interstate. It is not, there is no will. If I file this case, there is no question of my admission in the cross-examination except for my mental state. That some signature was shown to me, I have admitted it. When I am disputing the very will itself.
For probate was filed by your mother.
My lord.
Yes. Maxi Matthias.
Yes.
Is his second wife or your mother? The second defendant is his stepbrother.
Yes.
All the other defendants are your own sisters and brothers.
Yes.
Your mother filed a petition for probate.
Yes.
You are arrayed as one of the respondents in that suit. Person interested to deny. With that, you have entered appearance and filed an affidavit. Please come to this, madam.
Yes, my lord. Page 64. I have only produced, my lord. Page 64.
Page 72.
72 months.
Your mother has given the names of all those persons who are the legal heirs of your father, including the defendant number 2.
Yes, ma'am. If your lordship may kindly see page 64, which is my affidavit. If your lordship may kindly see.
Yes.
Starts with page 63, which is exhibit D1, annexure G. Your lordship may kindly see down itself, it's clearly stating Halloween Christian inhabited. If your lordship may kindly see the first paragraph, having an address in Bombay, your lordship may kindly see. And also it says in...
Yeah, we'll come at 2:30, come back at 2:30.
Please, sir.
2016, please don't take an adjournment. I have no agreement. Sir, if there is an order of stay, what is the status of the suit? What is the stage of the suit? No, sorry, sir. The case will matter. Cannot end. Even if it is 1 hour, it is an adjournment. So I will not grant an adjournment. Right there. Please.
What officer? What officer? What officer?
Sir, ಹೇಳಿ.
62 ಡೇಟ್ ತಗೊಂಡ್ರಾ?
ಇದೆ ಸರ್, ಇದೆ.
62, thank you.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 65 ಅರ್ಜನ್ ಆಗಿಲ್ಲ ಅಲ್ಲ?
ಇದೆ ಸರ್.
ಇದೆ, ಥ್ಯಾಂಕ್ ಯು.
Anama did not file written statement. But if you already sold it to this different number 7, the different number 7 was to file the writ petition. How are you interested? Yeah, but you have sold it to different number 8. You already sold it. What is your interest? No, but the whole question is, whether Naranama is executed the sealed deed or not. Adhan seri adhan compare madadinge. How to know the truth? (1966) sealed deed idya? Will direct both the sealed deeds to be compared. Yes. I think, have you produced the original sale deed? 1966. Therefore, that bekebekalla. See, earlier what they said was, the application that was filed earlier was to summon the original thumb register of 1966 to enable the plaintiffs to take steps for referring the same for forensic science lab. Now they have filed an application under
Subsequently, again, they make a proposal. At the same time, now they say that particular indicator are available. How you solve?
this issue notice. In addition, Grand Counsel for the petition is directed to serve. The Grand Counsel presented the respondents 1 and 2 in this writ petition. Notice to the other respondents is dispensed for the present. Till the next date of hearing, further proceedings in OS number 4280 of 2012 on the file of this own support is stayed. Discount. The court has got the power, Mr. Yes, court has got the power. See, if you are a tenant, you are bound to pay the rent. If you say that you are not liable to pay rent because of ABCD reason, deposit the rent before the court. Let the court decide. Order 20, the moment you go to order 20, it comes only after the judgment is passed. Now there is no stage, there is no need for the court to go into conduct an inquiry because you admit the tenancy. If you don't admit the tenancy, it would have been different. Because you admit the tenancy,
which is already seen this.
yes.
Prayer for permission, prayer for rent, prayer for new property. Both may pass a decree of the possession of the property. B, for the rents which are occurred on the property during the period prior to DA, for the mean profits are directly inquiry as to such mean profit. Is in relation to not rent or amount paid during the period of the wedding. All these things are only at the way of application
Yes, perfect. The defendant in OS number 6203 of 2019 on the file of the Crown Court has filed this petition agreed by the order dated 16/7/2022, in terms of which, the court ordered the defendant to pay the agreed rent at the rate of rupees 1,08,000 per month from June 2019 and onwards. Stop. Next para. The suit in OS number 6203 of 2019 was filed for ejectment and for mean profits from June 2019 till mean profits at the rate of rupees 1,25,000 per month from June 2019 till the date of delivery of the vacant possession of the scheduled properties. Full stop. The suit was contested by the defendant. Full stop. During the pendency of the suit, the plaintiff filed an application under section 151 of CPC to direct the defendant to pay the agreed rent at the rate of rupees 1,08,000 from June 2019 onwards. Full stop. The application was resisted by the defendant, who claimed that the plaintiffs came in the way of the defendant enjoying the suit premises, inasmuch as they did not allow the power tariff to be changed from LT 31N to LT 5AN. Full stop. It is also claimed that the plaintiffs had lodged a complaint against the defendant using the premises without obtaining a trade license, which resulted in passing an order by the municipal corporation. Therefore, it is further submitted the plaintiffs had disconnected the electricity and water supply to the premises in question, and therefore did not allow the defendant to utilize the premises in question for the purpose he had taken it on rent. He therefore contended that he was not liable to pay the rent during the pendency of the suit. Full stop. The trial court, after considering the contentions urged, allowed the application and directed the defendant to pay a sum of rupees 17,28,000, being the arrears of rent from June 2019 till September 2020. It further directed the defendant to pay sorry, 2020. Full stop. Being agreed with the said order, the present writ petition is filed. Next para. Learned counsel for the petitioner submitted that since the defendant was not permitted to use the premises in question for the purpose he had taken on rent, comma, he was not liable to pay the rent. He further submitted that the suit was for ejectment and also for recovery of mean profits, and therefore the trial court could not have passed an interim order directing the defendant to pay the rent, which was in the nature of mean profits. To stop, the counsel invited the attention of the court to Order 20, Rule 12 of the Code of Civil Procedure to contend that the question of payment of mean profits would arise only after a decree is passed in the suit. To stop. Next para. Per contra, the legal counsel for the respondent submitted that the defendant did not dispute the tenancy of the premises in question, as well as the rate of rent. Full stop. He submitted that mean profits claimed in the suit was a sum of ₹1,25,000, while the admitted rents had to be paid by the defendant. Full stop. In this regard, he invited the attention of the court to Order 39, Rule 10 of the Code of Civil Procedure, and contends that the defendant is liable to pay the admitted rent. Full stop. Next, I consider the submissions made by the learned counsel for the parties. As rightly contended by the learned counsel for the respondent, comma, the petitioner has admitted the tenancy as well as the rent, as well as the date from which he became due. Full stop. The question of determining mean profits at the rate of 1,25,000 would arise only after the court passes a decree. But in the present case, comma, since the petitioner has admitted the tenancy as well as the rate of rent and the date from which he defaulted in the payment of rent, comma, there was no issue that had to be considered by the trial court. There is no issue. Comma, the same was an admitted liability that the petitioner owed to the petitioner, and therefore, comma, the trial court was justified in directing the petitioner to pay the admitted rate of rent and also admitted rate of rent and the arrears from June 2019. Full stop. The trial court was invested with the power to do so under Order 39, Rule 10. Therefore, comma, no interference is warranted in this expedition. Hence, the expedition is dismissed. Petitioner is directed to continue to deposit the rent at the rate of 1,08,000 per month before the trial court. You are passing an order, Mr. You are bound to pay the rent. So, have you denied it? Have you denied it? Where have you denied the rate of rent? Which page? Yes. Yes. How much is the rate of rent according to you? No, that is not enough, Mister. You admit that. You do not admit the lease agreement. Do you not admit? No, do you not admit the lease agreement? Lease agreement. Yeah, only the lease agreement. There is no lease agreement. Please read paragraph number 5. 39 Rule 10 is not applicable until 39 Rule 10 is applicable. If you want, I'll quote you at least about 100 judgments on that. It's an admitted liability, Mr. Venktesh. I think more wherever denied the existence of the agreement.
That is for the prior period. The enhanced rent is not there.
Hmm.
So the
Yeah, what have you admitted? Please tell me that. What have you? Was it? Hmm. So let us see what is the averment made in paragraph number 5 of the plain. Hmm. Yes. No, the next one. What about paragraph number 6? 6. Hmm. Now read the next paragraph. Hmm. Hmm. You read your paragraph, the paragraph number 8 of the written statement.
That is page 46. Is evident in terms of regarding paragraph 8. Is evident in terms of the above to go pay total rent of rupees 1 lakh per month.
That is defendant plaintiff antide. It should be defendant, not plaintiff.
Yes. The month by deducting periods from 50 to 22. Thereafter, upon
what more you need? What more you need? The government made in this paragraph is true and correct.
That is about the agreement which is for the period 15 to 18 to 15 to 19. Thereafter, there was no fresh agreement.
Please read further, Mr. Thereafter, upon the continue to depart. Obviously, Mr. That's an admitted liability. Mr. Even you are bound to pay throughout the pendency of the suit, whether you let without an inquiry only, because it is an admitted liability. It's an admitted liability, Mr. Don't you admit your liability of 1,08,000? No, don't. First of all, please, do you admit your liability or not?
Then the next term means we refer to the para 9 of the grade, which is answered in para 9 of the legal statement. And I have denied that specifically not limitation. Paragraph 9.
What about paragraph number 8 of your written statement?
8 only in relation to governments made in a contract for an
Don't-
earlier period.
Please read again.
I read it.
Take your time.
Paragraph 37. I am only worried not because the market is other condition.
It will.
Without getting a
It will. You are bound to pay. You're bound to deposit. You're not saying,
Why not? Why you
I don't know. If it's an admitted liability, I don't think you need to be a law genius. If it's an admitted liability, you have to deposit. Mugitu.
even if I go to market,
Please read your written statement again.
yes, Paragraph 9. Paragraph 9.
At least in paragraph number 8, do you admit that you accept the averments in that paragraph? Is true and correct. Therefore, you admit it. It is admitted.
Paragraph 8. It is there, it is admitted there in black and white in relation to terms of earlier. Then what in relation to this particular period is paragraph 9. And it is that if that admission was sufficient, or there was no requirement, paying also to have both para 8 and 9. Because para 9 is not yet currently. Paragraph 9 is different.
Correct. Vodi, take your time. You take your time. You please convince me.
Yes, paragraph 9. It is submitted that in total rent of 1 lakh on the date of activity, the defendant had only being paid only 64,000 by the respective periods of this order, and did not pay the rent for the month of March, April, July, and check the income of so there is also a one. Each issue by the defendant will be paid on a 100 reverse period and month of August. And the rent paragraph 12 in relation to read earlier. In relation to denial of rent. Paragraph 12. With regard to paragraph number 12 of the play, it is submitted that as per the opposite interview, the defendant is bound to pay the enhanced rent of 1 lakh from 15 to 2019. Accordingly, the defendant paid the same up to May 2019, the draft is set amount to the account of and she never limited any amount to the account of though she is bound to remit the amount as per she set agreements. The government made in this paragraph totally so what is stated in paragraph 5 is that for this period, the rental amount was 1 lakh because being paid by the plaintiff for 3 months. I have denied it totally.
Therefore, you have denied the fact of not paying the money.
And also the rent amount.
The innocent.
The entire paragraph is denied.
Read it, please. Read it.
It is submitted that as per the opposite rental agreements, the defendant is bound to pay the enhanced rent of 1,08,000 from 15 to 2019. This is 1 hour rent. Accordingly, the defendant paid the same up to May 2019 by transferring set amount to the account of plaintiff number 192. This is another government.
Yes.
And she never remitted any amount to the account of plaintiff number 3. Though she is bound to remit the amount as per the schedule, this is the third government in the same paragraph. The awareness made in this paragraph totally denied us.
So therefore, now you please come to averment made in paragraph number 8 of the written statement and compare that with the plaint averment. Compare that with the plaint averment.
Paragraph 8 of plaint.
Yes, paragraph 8 of the written statement.
Yes. Paragraph 8 of the It submitted that in terms of the adopted agreements, the plaintiff is bound to pay total rent of 1 lakh from 15 to 2018 to 15 to 2018. And thereafter, upon mutual consent, if the defendant continue her tenancy, she will have been paid enhanced rent of 1 lakh by adding 8% to the earlier fixed rent. Again, but there are 2 different governments here.
That is the mistake. Can't help it.
But the mutual consent is not there.
No. If you want to withdraw it, you withdraw it. But even if you withdraw, if you don't withdraw it, or even if you withdraw it, the application is bound to follow. You're bound to deposit the monthly admitted rent, Mr. Even if you don't like it, that order is bound to follow. It is bound to follow. You're bound to pay the admitted rent. Really, what is this? Yes, yes. You want to withdraw it and leave it to you. But this order will remain. This will remain. Yes. ಎಷ್ಟು ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಎಷ್ಟು ಕೊಡ್ಬೇಕು ಸರ್? 5% ಕೊಡ್ಬೇಕು. ಎಷ್ಟಾಗುತ್ತೆ? 20,000 ಪೆನಾಲ್ಟಿ ಎಷ್ಟಾಗುತ್ತೆ? ಪೆನಾಲ್ಟಿ 10 times. ಎಲ್ಲಿ 1 time ಅಂತ ಎಲ್ಲಿದೆ? ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ 2,000 ಎಷ್ಟಾಗುತ್ತೆ? ಪೊಸಿಷನ್ ಕೊಟ್ಟಿದೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಸರ್, ಎಷ್ಟಾಗುತ್ತೆ ನೋಡಿ. What is total consideration? 40,000. So 5% 2,000 ಆಯ್ತು. 22,000 ಕಟ್ಟಬೇಕು. Issue notice. In addition, the learned counsel for the petitioner directed to serve the learned with CGP. The interim order, impugned order dated so and so, passed by the so and so court in OS number so and so is state. Okay, CGP ಮಾತ್ರ ಕೊಡಿ ಸಾಕು. Counsel for the petitioner submission needful is done. Office is directed to check, verify and proceed to issue notice. Same on. Yes, same on. Yes. Then there seems to be a communication gap between Mr. Shivaram and you. Password. Who is filed for? I think. What is the stage of evidence? Whose evidence? 2017 ಅಲ್ಲೇ ಇದೆಯಾ? What has the appellate court done? What has the appellate court done? ಇದೇ ಈ ಕಡೆ ತೋಡು ಅಂತಿದೆಯಲ್ಲ, ಇನ್ನೇ ಒಂದು ತೋಡು ಅಂತಿದೆಯಲ್ಲ ಈ ಕಡೆ.
letter of produced by the defendant. To the 1886 law. There it is shown that it is a 2-meter road. It's actually in fact and was
Anyway, you've been using this pathway.
I'm not using the pathway, but I'm using this pathway road. Only for the purpose of taking the back twice a day. It itself is a network. Take the car to the road in the morning and evening. Now, my lord, because of the election being dismissed, but earlier we had the very strong disease, and this light cannot be changed with the knowledge of the defendant. So this is a subsequent revelation.
Where is the report of the commissioner? ಅಲ್ಲೆಲ್ಲ ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಅನ್ನು ಸೈಟ್ ಮಾಡೋದು ಹಿಂಗೆ ಆಗೋದು. What is there to show that there's another road for the plaintiff? The access is. There is a municipal road. Please come to document number 6. Ah. 4 feet road ಅದು ಏನು? ಇವಾಗ ಇಲ್ಲಿ ನಿಮ್ಗೆ ದಾರಿ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ? That is 4/100 ಆಯ್ತದು.
I was claiming from the municipal road, one of the defendants property, the registry road. So they have proved that I was passing before the well was there. And also next to my house, that was the road I was using. That is R2 in the weekdays.
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. Direct the trial court to explain this. No, but see, look at the construction that is already put up. ಬಾವಿ ಇದೆ.
Is covered now. They have covered the well. So where they also their property to that road itself. So that is an interest of them.
ಇಲ್ಲಿ ಅದರ್ ಸೈಡ್ ಯಾರಿದೆ? ಸರ್ ಹೆಗ್ಡೆ ಹೂಡ್ಲೆ ಬನ್ನಿ.
My only submission is until the suit is decided on merits. But initially I had the initially. My only endeavor is that I will be permitted to take the same passage like using.
No, we'll only permit, direct the defendant to maintain status quo in respect of the property. We cannot use it. Let him not put up any construction till the. Let that status quo be maintained. No. Correct, compound according to the building.
That's the gate for this.
You are lost in both the courts. There is an alternate. There is an alternate road through which you can access your property, maybe not by car. We will continue to use it for some time till the suit is disposed.
The wrong appreciation of the facts.
No wrong appreciation. Will direct the defendant not to develop any property. Why are you worried? If you succeed in the suit, you will get it. Purport. The plaintiff in OS number 117 of 2017 on the file of the third edition citizen James Udupi has filed this petition agreed by the order dated 14/6/2017, rejecting his application for interim injunction to restrain the defendant from obstructing or digging a well in his site to obstruct the passage that the plaintiff was using to access his property. The plaintiff is also agreed by the order dated 5/8/2017 in MA 20 of 2017 by which the order of rejection of the interim injunction was confirmed. Next paragraph. The suit in OS number so was filed for filed for declaration to declare that the plaintiff has a prescriptive right of way for the property of the defendant as shown in the I sketch attached to the plaintiff, and for mandatory injunction restraining the defendant, mandatory injunction directing the defendant to restore the road to its original condition, and for perpetual injunction. Full stop. Along with the plaintiff, an application was filed for interim injunction to restrain the defendant from closing the road through which the plaintiff was accessing this property. Next, the defendant contested the suit and claimed that the plaintiff has an alternative road which he could use to access his. He also denied that the plaintiff was using any portion of his property for the purpose of a road. So the trial court, after considering the contentions urged by both the parties, rejected the application filed by the plaintiff on the ground that the plaintiff had an alternative road. Stop. This was confirmed by the appellate court in appeal. After being agreed by the said order, this petition is filed. Next paragraph. During the pendency of this petition, the commissioner was appointed who submitted his report, which indicated that the plaintiff, an alternative way existed to reach the plaintiff's property. Stop. The General Counsel for the petitioner submitted that this commissioner sketch indicated that the alternate road measured 4 feet into 100 feet which was not sufficient for the plaintiff to take his car from and out of the from and to his property, and therefore, status quo of the road as it existed through the property of the defendant be full stop. The learned counsel for the respondent, on the other hand, submitted that the plaintiff has no right whatsoever to pass over the property of the defendant. He submits that a well is dug in the area where the plaintiff claimed to be using it as a road, and therefore, no injunction can be granted in favor of the plaintiff against the defendant. Full stop. Next para. I have considered submissions made by the learned counsel to the parties. Next para. It is not in dispute that the plaintiff's property is provided with an access which, though measures 4 feet in width, is enough to access his property. The question that remains to be considered is whether plaintiff was using a portion of the property belonging to the defendant for the prescriptive period of 30 years, so as to claim a right to pass over the land of the defendant. Full stop. Until the same is established, the plaintiff would not get any right. Full stop. However, having regard to the location of the property of the plaintiff as well as the defendant, it is necessary to maintain the status quo of the property. It is necessary to restrain the defendant and it is necessary to restrain the defendant from putting up any construction in his property where the plaintiff claimed that a road existed. This is only to ensure that in the event of the plaintiff succeeding in the suit, his right to use the said road should be restored. So only to this limited extent, the defendant is restrained from putting up any construction in that area. However, this shall not mean that the plaintiff shall utilize this order to establish a road for the property of the defendant. Stop. Since the suit is filed in the year 2017, trial court is directed to expedite this. The expedition stands disposed of on the observed way.
For the respondent.
Yes, please.
There is already a lot in the equities. Therefore, I have to make available or the value of the property, not the value of the property. Therefore, how to do someone that the reputation of this is the process is not far. After we to pay 60 60 lakh, the market value of the property as on 2000. Actually, the compromise was made in 2009. And in that, I proposed the execution. And the airport has got the order. When is the order comes at 10 to that is as per actually first order, third and first order. And ultimately, the purpose is to period of the order. The degree holder is directed to government welfare as on the date of compromise. There is a direction providence act. This is as the date of compromise. Nine. Subsequently, he makes a memo. That is 6/10/2017 and page number 48. Copy at page number 48. And because I offered alternatives, he said it is not serious because the documents are run out, something like that. That's why I'm not clear on that. That was taking the plan of harassment and passing it to order. When we see, though there is already an order to provide guidance value, here the revenue is still only. It is there is the rank of 2014 or 15. Therefore, I have carried this order.
ಸೈಟ್ ಕೊಟ್ಬಿಡಿ, ಗಿವ್ ಎ ಸೈಟ್. ನೀವು ರಾಜಕಾಲುವೆ ಪಕ್ಕ ಇರೋದು, ಮೋರಿ ಪಕ್ಕ ಇರೋದೆಲ್ಲ ಕೊಡ್ಬೇಡಿ. ಇನ್ನು ಸೈಟ್, ದಟ್ ಈಸ್ ಎ ಕೇಸ್. ಅದೇ ಏರಿಯಾನಲ್ಲಿ ಒಂದು ಸೈಟ್ ಕೊಡಿ. ಎಲ್ಲಿ ಕೊಡ್ತೀರಿ? ಎಲ್ಲಿ ಕೊಡ್ತೀರಿ? ಇಲ್ಲಿರೋದು ಸೈಟ್ ಇದೆ. ಈ ಏರಿಯಾಲ್ ಕೊಡಿ. ಹೊಸಕೆರೆ ಹೇಳಿಲ್ಲ, ಹೊಸಕೆರೆ ಹೇಳಿ. ಹಾ ಕೊಡಿ, ಎಲ್ಲ ಕೊಡಿ, ಎಲ್ಲಾದ್ರೂ ಕೊಡಿ. ಹೊಸಕೆರೆ ಹೇಳಿ. ನಾವು ಕಮ್ಸ್ ವಿತ್ ಇನ್ DBMP ಝೋನ್. DBMP ಲಿಮಿಟ್ಸ್ ಅಲ್ಲಿ ಬರುತ್ತಲ್ವಾ? (2,400 square feet). ಕೊಡಿ. East by 25 feet wide road, west by private property, north by property number 57, south by property 60. ಕೊಡಿ. ಯಾವ್ದಾದ್ರು ರೋಡ್ ಫೇಸಿಂಗ್ ಯಾವ್ದಾದ್ರು ಕೊಡಿ. ಯಾವಾಗ ಹೇಳಿ?
One submission. So far as survey number 7 is concerned, my lord, wherein they said that they will give a site. It was subjected to, my lord, PTCL proceeding.
ಆಯ್ತು, ಬೇರೆ ಸೈಟ್ ಕೊಟ್ರೆ ತೊಂದರೆ ಇದೆ ನಿಮ್ಗೆ?
ಸರ್ವೆ ನಂಬರ್ 29 ಅಲ್ಲಿ ಸೈಟ್ ಕೊಡ್ತೀನಿ ಅಂದ್ರು, ದಟ್ ವಾಸ್ ಅಕ್ವೈರ್ಡ್ ಬೈ PDA.
ಆಯ್ತು, ಇವಾಗ ಅದೇ ಊರಲ್ಲಿ ಇನ್ನೊಂದು ಸೈಟ್ ಕೊಡಿಸ್ತಾರಂತೆ. ಯು ಹ್ಯಾವ್ ಎನಿ ಪ್ರಾಬ್ಲಮ್?
Let them, my lord, give all the title documents. Let them furnish the title documents during the next date of hearing. If the title documents are clear, my lord, my client doesn't have any problem.
Entry ಮಾಡ್ರ.
Execution petition has been stayed, my lord. The suit is at the year 2008.
ಯಾವಾಗ ಹೇಳ್ತೀರಿ? Next week ಹೇಳಿದ್ರೆ we'll direct you to deposit as per the guidelines of 2009. ಎಷ್ಟಿತ್ತು ಹೇಳಿ ಗೈಡೆನ್ಸ್ ವ್ಯಾಲ್ಯೂ? ಗೈಡೆನ್ಸ್ ವ್ಯಾಲ್ಯೂ ಎಷ್ಟಿತ್ತು 2009 ಅಲ್ಲಿ? Loan counsel for the petitioner submits that he will instruct the petitioner to identify an alternate site in the same village. Also furnish the guidance value of the property that was agreed to be sold to the decree holder in the year 2009. Based on wealth.
Yes.
Based on interim was extended till the next day.
I'm happy with the appellant.
Yes, please.
For the appellant, my lord.
Yes, where is the affidavit that is now filed?
Affidavit of my lord?
The affidavit which is now filed. Have you filed any affidavit? subsequent to filing this application,
Before the trial court, my lord?
yes, before the trial court,
That is not part of
you
the
have
record.
application to what you call strike off that evidence, isn't it?
Further examination is annexure M.
Annexure M.
M.
Did you file any application to strike off that portion of the evidence where you admitted the earlier probate?
Yes, that is the further examination, which was order was made by this trial court, which is under challenge before your lordship. The IA which was filed by, we filed this to IA 7 and 8, my lord, which was allowed with cost, and the defendants took the cost also. After that, when I filed my further chief examination, annexure M, this on this, the order was passed by the trial court, which is under challenge before your lordship. As a reasoned order has been passed, that is page 23.
Yes. No, you can't be saying this. How can you be saying this? Once you admitted the signature, how can you resile and say that this is a fake proceeding, no orders have been passed? Please see the affidavit, tenor of the affidavit at paragraph number 3.
May I read?
Proceedings initiated in petition number 187 of 91 before the High Court of Mumbai, confronted to me and marked as D2, is a fake proceeding, and no orders have been passed in the said proceeding by the Honorable Court. I say that when exhibit D2, D2A were confronted to me, I was not in a proper frame of mind to understand the question and realize what was the document that was being shown to me. I say that I have not seen the said document, exhibit D2 and D2A. The same was shown to me in the court. How can that be a fake proceeding?
My lord, what she says is her signature is not hers. That's what she is submitting. And here she saw only she doesn't even know which document has been shown to her. She only saw the signature. That's what she says in her affidavit also.
No, that is enough. How do you, once you admit your signature, how can you go back and say that there is no such will and all this?
My lord, before I further proceed, my lord, let me correct the status of the party, which was little confusion was there. So far as the appellant concerned, my lord, the serial number, that is defendant number 2 and 3, they are the step brother and sister. All the people are own brothers, sisters. What has happened is in the will, my lord, the father gives the share to only the sons. The daughters are given only the marriage expenses. That is what the will says, which she is telling that it is not correctly done like that. So now what she says.
On merits of the claim.
I understand.
When she was cross-examined.
Yes, ma'am.
Mr. Signature in respect of what you call affidavit filed before the High Court of Bombay.
Yes.
Mumbai. And she admits the will. Now can you go back and say that the proceedings before the Bombay High Court were all fake?
No, my lord, even that is the reason, my lord, I asked your lordship the time, because I told her, if that is the case, did you give a complaint, police complaint or something for the forgery or something? She said she will. After that, her husband died and she was into the corona problems. So I am not in touch with the client also, my lord. That is the reason I am morning asked 2 weeks time. I leave it to your lordship, my lord, as the matter is already argued. I will not. I leave it to you.
Lead further evidence, no issue.
Yes, ma'am.
You can't retrack your steps and say that I am not.
To that extent, if this lordship can protect that further evidence, and cross is also available for the other side.
Evidence you can do.
Further evidence and cross is available. Let her do her case.
Admission of the signature on exhibit D2.
Yes.
Will not permit you to backtrack.
I'll leave it to you, lordship, my lord. I finished my argument. Only point is like the access is there for the defendants for the cross.
Yes. But what objections can you have if the affidavit, with the signature of this plaintiff, if she does not withdraw that admission, you can cross-examine her on other aspect. What other aspect will be there? There will be nothing. The petition for probate is filed in Bombay. There is no opposition. On the contrary, she files an affidavit saying that I don't have any opposition to grant probate. Based on that, probate is granted, the signature is admitted. So if she wants to lead any further evidence apart from that, let her lead. Now, madam, she is not denying, we will not permit her to deny. You have any objection? Let her lead further evidence in respect of any other thing other than this signature. Yes. This one will dispose it off with that observation.
Please, ma'am.
Any other evidence apart from the signature found on that affidavit?
Please, ma'am.
Withdraw.
Please, ma'am.
Yes. Pass over. Mr. Harish. Where is it? Yes. P. Narish. Who are they? Who is this proposed defendant? Who is he? Purchaser. From the second defendant. Who is the second defendant? Who is also one purchaser. Second defendant are in the purchase market.
The person who had not taken that day. Subsequently, 1964, they are vendors.
Mundraji in Bantu.
That is not their friend.
Huh?
They say that they are the dealers of this.
Mundraji in Bantu.
Mundraji is the clients have the dealers of
Mundraji Bandiru, Gundapun Kadendana Bandiru. Mundraji in the new town, in my vendor town. Mundraji sold it to this Syed Sirajul Hussain. Ashwathappa did not get the property from my lord. Ashwathappa did not get the property from my lord.
No. He got the property from governor. He has Ramaswamy and he has Vedula.
No. Ashwathappa did not get the property from my lord.
According to this data of Ashwathappa, according to GS Ramaswamy and Vedula. Only this person are involved. I don't know that a lot of money is that. These mutual property are listed in the activities. That is state and the. Page number 22. Inside cargo, after cargo survey number 32, according to the vacant. There are the property purchased by the notice of this building. And even in my application statement are specifically say there that the mutual property is property part of the relevant. There is no mutual property as claimed in existence. But the government plans that do not completely restrained by the statement of the nation and say if you are the proposed and administration the culture of the mutual property. And you see that there is no. Statement about it. But as specifically in the function of the social property. And in the law itself, there is a mention of my favorite about it. But we were trying to see. Page number 43.
No.
What is the he also further stated that property which is altogether different and has nothing to do with the property, the necessary this is not better. How come you very much to believe it will not matter that. The right judgment is these are the no, I am not talking the rented child owns the application saying that you are interested that is absolutely not right. Again, you got the statement of institute property, which is that is only the right aspect I can see notice. Extent of the area over 92 square feet. What is mentioned in the last aspect I can see. The same board is how the proposed dependent has purchased the same property. The not mentioned within the same production can be student property. Same. Only with some differences are in random. The second dependent,
just wait, please wait.
Proposed dependent, he admits that the same property as sold property, they are fully proposed dependent.
Yes.
But whether we constructed this property, that is used property is there.
Whatever it is, the boundaries match.
This mechanism, especially east west 7 feet. You might say that it is mentioned as east west 55 feet and north west 7 feet. And it was a constructed property. So when you start building,
But look at the schedule boundaries. Look at the boundaries.
the boundaries are but there is no mention of building at all.
All right. If the boundaries match, then you have purchased. When did you purchase it? When did you? When was the suit filed? 4/6/2012. From whom did you purchase? Then face the proceeding. We permit you to file a statement. Barkul. Proposed defendant in OS number 3886 of 2012 on the file of the 24th AC, C and SJ, Bangalore City, has filed this petition challenging the order dated 5/1/2016, by which he was ordered to be put on record as defendant number 3 in the suit. The suit in OS number 3886 of 2012 was filed for partition separate possession with respect of a property with respect of a site found in survey number 10 of Devara Jeevanahalli, Bangalore North Taluk. The defendant filed his written statement contending that he had sold away the property to the proposed defendant on 15/3/2012. Full stop. Following the aforesaid statement, the plaintiff filed an application to implead the proposed defendant as defendant number 2 by an application filed under Order 1 Rule 10(2) of the Code of Civil Procedure. The said application was allowed in view of the assertions made by the defendant in his written statement. Being agreed with the said order, the present petition is filed. Next, the learned counsel for the petitioner submits that the proposed defendant did not purchase the property. Sorry, the vendor of the proposed defendant did not purchase the property from the defendant number 1 or his ancestors, but was purchased from Ashwath Tappa, who was in no way related to the plaintiffs or the defendant number 1. He therefore submitted that the proposed defendant was not a proper or a necessary party for the adjudication suit. Per contra, the learned counsel for the Stop. Per contra, the learned counsel for the plaintiff submitted that in terms of the sale deed dated 15/3/2012, what the proposed defendant had purchased from the defendant number 2 was the suit schedule property. The learned counsel has placed on record a copy of the sale deed dated 15/3/2012. Full stop. The learned counsel for the proposed defendant countered the argument of the learned counsel for the plaintiff and contended that he had not purchased the suit schedule property, as the suit property was comprised of a constructed building when he purchased it. Full stop. Next para. I have considered submissions made by the learned counsel for the parties. Next para. The boundaries mentioned in the suit. Part is next para. The suit was filed for partition, separate possession in respect of a property with specified boundaries. Full stop. It is seen that the defendant number 2 was a purchaser, had conveyed a property which was more or less similar to the had conveyed a property lying within the boundaries which was more or less similar to the boundaries mentioned in the suit. Full stop. Therefore, the proposed defendant was a proper and necessary party. Was a proper and necessary party for the adjudication of the dispute. In that way of the matter, this court does not find any error in the order passed by the trial court. In the way of the matter, the petition lacks merit and is dismissed. It is open for the proposed defendant to file his written statement post the suit. Shankar, but ಹೇಳಿ ಸರ್ ಆದ್ರೆ ನೋಡೋಣ ಆದ್ರೆ ಅಡ್ಗೆ ಮಾಡೋಣ Review is dismissed. ಆದ್ಮೇಲೆ ನೀವು ಇದಾಕೋಬೇಕಲ್ವಾ MSA ಪೆಂಡಿಂಗ್ ಇದೆ ಅದನ್ನ ಪರ್ಸ್ಯೂ ಮಾಡ್ಕೊಳ್ಳಿ ಹೇಳಿ ಏನು ಯಾರಿದ್ದಾರೆ ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ಹೇಳಿ ಏನು ಅಂತ ಹೇಳ್ಬಿಡಿ Let us see what is the order passed in the appeal. But review petition, one the writ petition, no MSA ಏನಂದಿಯಾ? So you could not have filed very abundant partitions. How can you file 2 petitions? That I understood. See, in the regular appeal, against allowing the order, allowing the appeal, you filed a misdemeanor is a second appeal. Thereafter, you file a review petition. Right. How can you file 2 petitions is what I am asking. One against the review, one against the RA. Tappalwa. Either withdraw one of them or I'll dismiss both. Grand counsel for the petitioner seeks permission to withdraw. WP number 20095 of 2016. The submission, Grand counsel Sri Shankar Narayan Bhattan, counsel Sri Shankar Narayan Bhatt N seeks permission to withdraw WP numbers also. The submission is placed on record. The petition is dismissed. Post MSA 42 of 2016 before the appropriate bench having lost. In the meanwhile, the counsel for the appellant is directed to pay the process to issue notice to the respondent, failing which regarding
the interim Because it's have because the existing building will show and the extent of what demarcation is within the forthcoming that you're filing a fresh body there, but it's not shown running across the that's what we have shown in the bottom up. The same thing has been drawn across the way.
No, but this and this, the sketch at page 21 of the writ petition does not tally with the sketch that you have given now. Huh?
What is happening in that rule sketch is not online across not across. We showed water. We showed the line here.
Please go to the sketch. Please wait. Please go to the sketch page number 21 of the writ petition.
One is also kind of case 24 and one is a case the two items.
Correct. No, but you look at
21 is with respect of item number 1. 24 is another. I think maybe a lot seen, but it's 24.
24 is the whole sketch, I think. 24 is the whole sketch of the property. Does it represent the entire? Whatever sketch that you have given now, this clearly corresponds to the sketches page number 24. This sketch that you have given now, it corresponds to the one at page number 24. But at 21, there is something else. No idea.
Because there's an existing building, it didn't run a line across.
What is your problem? Photo? I think you other need only. If that is the case, you take the other property. If you think that other property is bigger than this, take the other property. Page number? Vintage son of Chitta Hanumaya. Page number 16. Come to page number 16. He has signed. Date where 2010 alla. It also affixed the date. How do you say that you did not have the notice? Instead, you deny the signature. It is your own writ petition. You have produced it. Chitta Hanumaya. Chitta Hanumaya.
Not very
This 1/4 share is it? 1/4.
Yes. Right. There's an existing building that the walls will have to be clear and as per the building. But only in Raman. It doesn't make any sense to personal.
What application? There, Hanumaya and there. Who is Hanumaya? Son of Honnappa, R1. R1. Where is your objection? ಆಯ್ತಪ್ಪ ರಿಪೋರ್ಟ್ ಬಂತಲ್ಲ page number 25. Let us see what are your objections. Let him argue. ಈ ಅವ್ರದಾನೆ ಕೋರ್ಟ್ ಫೀಸ್ ಕಟ್ಟೋದು ಅವರು ನೀವಲ್ಲ. Yes. ಎಲ್ಲಿ ಹೇಳಿದ್ರೆ 33 ಅಡಿ 3 ಅಡಿ 27 ಅಡಿ ಅಂತ ಇಲ್ಲ ಅದೆಲ್ಲ ಎಲ್ಲಿ ಹೇಳಿದ್ರು? This is an armchair defense. ಸುಮ್ಮನೆ ಎಲ್ಲ ಆಫೀಸಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಬರೆದ್ರು ಅಂದ್ರೆ ವಾಟ್ ಇಸ್ ದಟ್? ವಾಟ್ ಇಸ್ ಎ ಮಿಸ್ಟೇಕ್? ಆಯ್ತಪ್ಪ, now there is a report. There is a report before the court. There is a report before the court. You are aware of the report. You are aware what are the mistakes in the report. Why did you not point out what are those mistakes? What mistake is there? Yes, yes, Mr. Who was the commissioner? BDNT surveyor. Can it not be measured by a lawyer? Advocate ಮಾಡಕ್ಕಾಗಲ್ವಾ? It's a matter of faith. If it can be done, why not? We'll keep this repetition pending. In case if it corresponds with this map, then we'll dismiss this repetition. Can be a problem. You want to know that? Junior advocate to senior alla anta andre ಏನು ಮಾಡೋದು? Madam, are you willing to go as a commissioner? Yes. You know how to measure on a tape? You don't know how to measure on a tape. Can you go? You have to divide a property into 4 bits, equal bits. Can you do it? Is to court commissioner fee. Still. Where is the property? Chamarajpet. 10,000 rupees kudi. 10,000. Huh? 10,000 rupees. Barcode. In this writ petition, the petitioner has alleged that the commissioner appointed by the final decree court did not visit the property and that he prepared a sketch dividing the property into 4 shares without taking into account the actual measurement of the property and the passage that exists in the property. He submits that the sketch was prepared in the office of the commissioner and the trial court did not consider the contentions urged by the petitioner in that regard. He invited the attention of the court to an application filed by the petitioners in the FDP 115 of 2012 who also conceded to the above fact and contended that the sketch drawn by the commissioner be set aside as it was done without following the principles of law, natural justice. The petitioners in FDP ಅಂತ ಹೇಳ್ತಿರೋದು. Next, per contra, the legal counsel for the respondents submit that they do not have any objection for an advocate commissioner to visit the spot and bifurcate the properties into 4 equal shares. He submits that since the suit property is comprises of a building, he submits that the commissioner was appointed by the final decree court has divided the property into 4 equal shares and has even given the measurement of each of the shares and therefore there is no discrepancy. He however submits that they have no objection for appointment of a court commissioner, appointment of an advocate as court commissioner to go to the spot and draw a sketch of the property, dividing it into 4 equal shares. He submits that if the sketch of the advocate commissioner and the sketch drawn by the commissioner appointed in FDP tally with each other, then there is no need to interfere with the sketch drawn by the commissioner appointed in the final decree proceedings. So since both the parties have conceded to appointment of an advocate commissioner, an advocate was present in the court, this Shravya is appointed as a court commissioner who is directed to inspect the property, take into account the passages as it stands, passages, alleys, etc., staircase, etc., as it stands, and divide the properties into 4 equal shares and give a clean give the measurement of each of the shares that have fallen to the respective sharers. to stop. In order to aid the commissioner in arriving at the measurements, a copy of the sketch already drawn by the commissioner in final decree proceeding shall be made available to the commissioner. So the commissioner shall visit the spot on what day is convenient to you? 17th. 17th. On 17th. 17th is okay. 10th is difficult. On 17th September 2022 at 11 a.m. Full stop. The parties are at liberty to be present at the spot. So the commissioner shall inspect the property and draw a sketch with measurement and divide the properties into 4 equal shares and submit a report before this court by 24th September 2022. Dismiss petition on 26 September 2022. The commissioner's fee is tentatively fixed at a sum of rupees 10,000, which is payable on 17 September 2022 by the petitioner's hearing. Yes. No notice. No memo of instruction. She will go, she will measure, she will cut it into 4 pieces and bring it before the court. Bring the sketch before the court, not the block. Oh. Yes. Current counsel, Ms. Shravya, appearing for the petitioner, submits that the petitioner is dismissed as withdrawn in view of the who cannot petition dismissed as withdrawn. Please take this copy. What is the property? No, what is the suit property? No, what is the suit property? What does the court say? Yeah, Mr. V.K. Ramesha. Yes, madam. Yeah. No, but this is a consequential remedy, madam. Cancellation of the agreement of sale is a consequential remedy. The possession. Correct, madam. Please go to the plaintiff. Plaintiff possession ಬಗ್ಗೆ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ? ಆಯ್ತಾ ಜವರೇಗೌಡ ಕೇಸ್ ಕರೆಕ್ಟ್ ಅಪ್ಲೈ ಆಗುತ್ತಲ್ಲ. ಸೆಕ್ಷನ್ 7(2) ನೋಡಿ, ಅಲ್ಲಿ ಇಲ್ದಿದ್ರೆ ಇಲ್ಲಿ ಅಂತ ಏನಿಲ್ಲ. If it's an agricultural land for the purpose of section 38, this is the way it has to be valued on the road. Yes. Whatever it is, once it comes under section 38, if you say that it comes under 38, and if it's an agricultural land, there's a benefit provided under section 7(2). See, you can't force a farmer to file a suit by paying lakhs and lakhs of rupees as court fees. That's the purpose, Uddesha. That is the purpose. Now, how can you get over that? Yeah, amendment of the plaint. I think even if it is for recovery of possession under section 24B, 24A now, yeah. 24A now counter kuda it has to be valued under section 7(2) only. How are you justifying this? Possession ಬಗ್ಗೆ ಎಲ್ಲಿ ಹೇಳಿದ್ರು? ಕೋರ್ಸ್ ಓದಿ. ಆಯ್ತು ಓದ್ಲಿ ತಡ್ರಿ. Let us read. Right, madam, see this. So, Javaregowda case alli, that was a case of a release deed. Release deed ಅಲ್ಲಿ consideration ಇರ್ಲಿಲ್ಲ. So, natural love and affection ಅಂತ ಅಂದ್ರು. ಅದಕ್ಕೆ ವ್ಯಾಲ್ಯೂ ಹೆಂಗ್ ಮಾಡೋದು? 24 ಡೀಲ್ ಹೋದ್ರು. ಕರೆಕ್ಟ್ ಅಲ್ವಾ? ಇಲ್ಲಿ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಅಲ್ಲ. Under section 38 it is only the value. Market value is different, value is different. That is the judgment of the Supreme Court in Sati Devi. If the market value is different and value is different, what is the value? Value agreed between the parties. What is the value agreed? The consideration. Correct alva? Idರಲ್ಲಿ, because it is an agriculture land, for example, on the other city property ತಗೊಂಡಾಗ consideration matters. Agriculture property ತಗೊಂಡಾಗ section 7(2) is applicable. ಆ ತರ ಮಾಡಿದ್ರೆ ಇದು ತಪ್ಪಲ್ವ ಮಾಡೋದು? ತಪ್ಪಲ್ವ? Requisition is allowed. What is the valuation slip now filed? Annexure? Petition is allowed, the impugned order is set aside. Consequently, the valuation slip filed by the plaintiff is accepted. Mr. G. Balakrishna. Pardon? What is the suit for? Suit is for injunction. ಏನಾಯ್ತು? Is it a vacant site or what? Vacant property now.
But after the commissioner, what is a pretty before the nearby the fire station and around the outdoor walk. They go
What is the stage of construction now? Huh? No, the defender has completed the construction. ಅದು ಹೇಳ್ಬೇಕಲ್ಲ, ಅದೇ ತಾನೇ ಮುಖ್ಯ. ಹಳೆ ಕೇಸ್ಗಳು ನೀವು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರೆ ಹೆಂಗಿದೆ? ಇಟ್ ಶುಡ್ ಕಮ್ ಪ್ರಿಪೇರ್ಡ್ ಮಿಸ್ಟರ್. ಯಾವ್ದು ಇವಾಗೆಲ್ಲ ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಬಂತು, ಎಲ್ಲ ಬಂದ್ಬಿಟ್ಟಿದೆ. ಈಗ ಒಂದು ಫೋಟೋ ಹೊಡೆದು ವಾಟ್ಸ್ಆಪ್ ಕಳಿಸಿದ್ರೆ ಕಳಿಸ್ತಾರೆ. ಹಿಂದೆ ಆಗಿರೋ ಬಸ್ಸಲ್ಲಿ ಕಳಿಸ್ಬೇಕಾಗಿತ್ತು, ಫೋಟೋ ಹಂಗೆ ಬರ್ತದೆ. ಎಸ್ ಸರ್, ವಾಟ್ ಇಸ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗಿದ್ಯಾ? No, if the construction has come up to such a level that it can't be used as a road, can it be used as a road?
The report of the commission is 18 feet selling this land. There is a class at the western side of the area. After 16 feet road area is reserved for reaching the other properties of the vendor and on the northern side. That is a reservation class. So that is the facility that passes. This is not about serious.
Trial court injunction is refused. ಮುಂದೆ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಹೌದು, ರಿಜೆಕ್ಟ್ ಆಗಿದೆ, ನಿಮ್ದು ಅಲೋ ಆಗಿದೆ. ನಿಮ್ದು ಕೌಂಟರ್ ಕ್ಲೈಮ್ ನಿಮ್ದು, ಸೊ ನಿಮ್ದು ಅಲೋ ಆಗಿದೆ. ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ. ಅಪೀಲ್ಸ್ ಬೈ ದ ಅಪೀಲೆಂಟ್ ಆರ್ ಸೌಂಡ್ಸ್ ಇದು ಅಲೋಡ್. ಆರ್ಡರ್ ಸೌಂಡ್ಸ್ ಸೆಟ್ ಅಸೈಡ್. ಮ್ಯಾಟರ್ ರಿಮಾಂಡ್ ಆಗಿದೆ. Considering the objection filed by the plaintiff to the report of the court commissioner. Let the trial court decide this case. No, you please look at the order passed to the appellate court. ಆಯ್ತು ಇದಾದ್ಮೇಲೆ ಏನಾಗಿದೆ ಸ್ಟೇ ಇದೆಯಲ್ಲಿ ಲೆಟ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡಿಸೈಡ್ ಬೇಸ್ಡ್ ಆನ್ ದ ಅಬ್ಸರ್ವೇಷನ್. ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ದ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಪಿಟಿಷನರ್ ಯಾವತ್ತು ಬೇಕು ನೆಕ್ಸ್ಟ್ ಸೋಮವಾರ ಆಗುತ್ತಾ ನೋಡಿ ಎಷ್ಟಿದೆ ನೋಡಿ. Interim order is extended as a last chance. As a is extended. Full stop. How do you? ಕೊಡ್ತಾ ಇದ್ದಾರೆ. MN ಮಧುಸೂದನ್. There. Suit is for injunction. Injunction suit. What is the suit property? Suit property in Maraya. Site number 5. What is the application sought filed for injunction? ಏನಾಗಿದೆ? ಎಷ್ಟು ತಪ್ಪೇನಿದೆ ಹೇಳಿ. Suit shall see property as what is the suit shall see property?
My property is schedule is property of the defendant. Schedule is property of the defendant. So we will go and operate as per the license.
ತಪ್ಪೇನಿದೆ? ಆಯ್ತು, ಇವಾಗ ನಿಮ್ಮ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಸೆಟ್ಬ್ಯಾಕ್ ಅಲ್ಲಿ ಕಟ್ಟಬೇಡಿ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. ನಿಮ್ಮ ಪ್ರಾಪರ್ಟಿನಲ್ಲಿ 2.5 ಅಡಿ ಇಂಟು 40 ಅಡಿ ಕಟ್ಟಬೇಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಸೊ ಕಟ್ಟಿದ್ರೆ ಮಾತ್ರ why do you file a writ petition then? ಕಟ್ಟಿಲ್ದಿದ್ರೆ if you not constructed any building in this 2.5 feet into 40 feet. ಏನಂತ? ಅಲ್ಲಿಗೆ ಅಲೋ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ಓದಿ, ನೆಕ್ಸ್ಟ್ ಸೆಂಟೆನ್ಸ್, ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ ಓದಿ. ಸಿ ಪ್ರಾಪರ್ಟಿ ಅಂದ್ರೆ ಏನು? ಪೇಜ್ 19 ಬನ್ನಿ. ಈ ಪ್ರಾಪರ್ಟಿ ಅಂದ್ರೆ ಏನು? ಓದ್ ಸೈಟ್ ನಂಬರ್ 5 ಅಪ್ಪ, ಸೈಟ್ ನಂಬರ್ 5 ಸರ್ವೆ ನಂಬರ್. ಅಲ್ಲಿಗೆ ನಿಮ್ಮ ಸೈಟ್ ಅಲ್ಲಿ ಅವರ ಪಕ್ಕದ ಪಕ್ಕ ಅಂದ್ರೆ ಇವ್ರ ಆಸ್ತಿ ಇದೆ, ಪ್ಲೈಂಟಿಫ್ ಆಸ್ತಿ ಪಕ್ಕದಲ್ಲಿ 2.5 ಅಡಿ ಇಂಟು 40 ಅಡಿ ಏನು ಕಟ್ಟಬೇಡಿ ಅಂತ ಕೇಳಿದ್ದಾರೆ. ನೀವು ಕಟ್ತಿಲ್ಲ ಅಂತಂದ್ರೆ ನಿಮ್ಮ ಪ್ರಾಬ್ಲಮ್ ಏನಿದೆ? ಯು ನಾಟ್ ಪುಟ್ ಅಪ್ ಎನಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ 2.5 feet into 40 feet ಮಾಡಿದಿರಾ ಇಲ್ವಾ? ಮಾಡಿಲ್ಲ. ಮತ್ತೆ ಇವಾಗ ಪ್ರಾಬ್ಲಮ್ ಏನು? ಹೌದಪ್ಪ, ಇವಾಗ ನಿಮ್ ಪ್ಲಾನ್ ಪ್ರಕಾರ ಇಷ್ಟಿರೋದು, ಎಷ್ಟು ಬಿಡ್ಬೇಕು? ನಡು ಜಾಗ ಎಷ್ಟು ಬಿಡ್ಬೇಕು? ಅವ್ರ ಆಸ್ತಿಗೂ ನಿಮ್ಮ ಆಸ್ತಿ ಮನೆಗೂ ಎಷ್ಟು ಜಾಗ ಬಿಡ್ಬೇಕು ಸೆಟ್ ಬ್ಯಾಕ್ ಪ್ಲಾನ್ ಪ್ರಕಾರ? ನೋನು ಇಷ್ಟೊತ್ತಲ್ಲ ಆಗಿ ಹ್ಯಾಬಿಟ್ ಆನ್ ಅಂದ್ರೆ ನಿಮ್ ಪ್ಲಾನ್ ಇದೆಯಲ್ಲ ನಿಮ್ಮ ಹತ್ರ? ಈ ಸಮುದ್ರಕ್ಕೆ ಧುಮುಕಿದಾಗ ಈಜು ಆಡ್ಲೇಬೇಕು. ನಾಳೆ ಬರ್ತೀನಿ ನಾಡಿದ್ದು ಬರ್ತೀನಿ ಅಂದ್ರೆ ಅಲ್ಲಿ ಆಗಲ್ಲ, ಇಲ್ಲ ಮುಳುಗೋಗ್ತೀರ. ಬೆಟರ್ ಯು ಲರ್ನ್ ಸ್ವಿಮ್ಮಿಂಗ್ ಪ್ರಾಪರ್ಲಿ. ಪ್ಲಾನ್ ಇಲ್ವಾ? ಕಾಪಿ ಇಲ್ವಾ? ಮತ್ತೆ ಪ್ಲಾನ್ ಪ್ರಕಾರ ಕಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೆಂಗ್ ಹೇಳಿದ್ರಿ? ಕರೆಕ್ಟ್ ಅಪ್ಪ, ನಿಮ್ ಪ್ಲಾನ್ ತಗೊಂಡಿದ್ದೀರಾ ಇಲ್ವಾ? ಪ್ಲಾನ್ ಪ್ರಕಾರ ಎಷ್ಟಿದೆ ಸೆಟ್ ಬ್ಯಾಕು? ಎಷ್ಟಿದೆ? ಇದೆಯಾ? ಕಾಪಿ ಇದೆಯಾ? ಕೊಡಿ. .75 meters ಅಲ್ಲ? 0.75 ಅಂದ್ರೆ 2.5 ಆಗಲ್ಲ. 3.26 2.5 4.45 2.5 ಅಷ್ಟು ಬಿಟ್ಟು ಕಟ್ಲೇಬೇಕಲ್ಲ? ಕಟ್ಟಿದ್ರಿಂದ ಮತ್ತೆ ರಿಟ್ ಪಿಟಿಷನ್ ವಿಡ್ರಾ ಮಾಡ್ಬೇಕಲ್ಲ? ನಿಮ್ಗೆ ಅರ್ಥ ಆಗ್ತಿದೆಯಾ ಇಲ್ವಾ? ಅಲ್ಲ, ಪ್ರಾಬ್ಲಮ್ ಏನಂತ ಅರ್ಥ ಆಗ್ತಿದೆಯಾ ಇಲ್ವಾ? ಈಗ ಇರೋದು ಇಷ್ಟು, ಅಷ್ಟನ್ನ ಬಿಟ್ಟು ಕಟ್ಟಿ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. ನೀವು ಅಷ್ಟು ಬಿಟ್ಟು ಕಟ್ಟಿದ್ದೀನಿ ನಿಂತೀರಾ, ಮತ್ತೆ ಇನ್ನು ರಿಟ್ ಪಿಟಿಷನ್ ಆಕ್ಟ್ ಹೌ ಡಸ್ ಇಟ್ ಸರ್ವೈವ್? ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಆದ್ರೆ ತೊಂದರೆ ಆಗುತ್ತೆ. ಕಟ್ಟಿ ಯಾರು ಬೇಡ ಅಷ್ಟು ಬಿಟ್ಟು ಕಟ್ಟಿ 2.5 ಬಿಟ್ಟು ನಂತರ ಕಟ್ಟಿ ಯಾರು ಬೇಡ ಅಷ್ಟೇನಾ 2.5 ಅಡಿ ಇಟ್ಟು 40 ಅಡಿ ಬಿಟ್ಟು ಕಟ್ಕೊಳ್ಳಿ. ಇನ್ನೇನಕ್ಕೆ ಕ್ಲಾರಿಫಿಕೇಶನ್ ತಗೋಬೇಕಾ? ಸಾಹೇಬ್ ಹೇಳ್ತಾರೆ ನೋಡಿ ಕೇಳಿ, ಪೊಸಿಷನ್ ಗೊತ್ತಿದ್ಯಾ? ಆಲ್ರೆಡಿ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್. ಇಲ್ಲಿ ಕಮಿಷನರ್ಸ್ ರಿಪೋರ್ಟ್ ಇಲ್ಲಿ
statement of objections.
statement of objections ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ. The commissioner, you are a corporation commissioner. ತಿಳ್ಕೊಂಡು ಹೇಳಿ, ಯಾವಾಗ ಹೇಳ್ತೀರಾ? ನಾಳೆ ಇಷ್ಟೆಲ್ಲ ಟೈಮ್ ಸ್ಪೆಂಡ್ ಮಾಡಿದ್ರೆ ತಿರ್ಗಾ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹೇಳ್ಬಿಡಿ. ನಾಳೆ ತಿಳ್ಕೊಂಡು ಹೇಳಿ. ಪರವಾಗಿಲ್ಲ ನಾಳೆ. ನೀನೇನು ಬಿಟ್ಬಿಟ್ಟು ನಿನ್ನೆ ಕಳ್ಸಿದಾರೆ ಅಂತ ಏನಕ್ಕೆ ಅಂತ ಅರ್ಥ ಮಾಡ್ಕೊಬೇಕು ನೀನು. Why not now? No, ನಾಳೆ ಎಲ್ಲ ಆಗಲ್ಲ. Request of the council for discount date.
I'm a lady of 85 years. I'm completely depending on my son. Because I have a practical difficulty.
Sir, ಈ ಫೈಲ್ ತಗೊಂಡ್ಬರ್ಬೇಕು. ಈ ಫೈಲ್ ಯಾವ್ದೋ ಫೈಲ್ ತಂದ್ಬಿಟ್ಟು ನೀವು 80 ವರ್ಷ ಮುಗಿಸ್ಕೊಂಡು
ಒಂದೇ ಕೇಸ್ among the same party ಸುಮಾರು ಕೇಸ್ ಇದೆ. ನಾನು ಸ್ವಲ್ಪ ಮಿಕ್ಸ್ ಅಪ್ ಆಗ್ತಿದೆ.
No, not sorry.
ಯಾಕೆಂದ್ರೆ 9
There's so many cases. ನಾವು ದಿನ 60-70 ಹಾಕ್ತಿದೀವಿ. ಆ 70 ದಾಟಿದ್ಮೇಲೆ ನಾವು ಇನ್ನೊಂದ್ ದಿನ ಕೊಡ್ತಿದೀವಿ. ಪ್ಲೀಸ್ ಆಸ್ಕ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವ್ರು ಯಾವ್ದಿದೆ ಕೇಳಿ, ಯಾವ್ದು ಕೊಟ್ಟು ತಗೊಂಡೋಗಿ ತೊಂದ್ರೆ ಯಾವ್ದಿದೆ ನೋಡ್ಕೊಡ್ರಿ.
I am appearing for respondent number 2, 3 and 4. That in last time of hearing, this honorable court has advised to file a memo to withdraw one of the prior in the written statement. Accordingly, I have filed a memo on 8/8/2022. In view of the memo, my lord, writ petition does not suffice.
Yes, flow appears for the petition. Yeah, copy ಕೊಟ್ಟಿಲ್ವಂತಲ್ಲ ಸಿದ್ದರಾಮಯ್ಯ.
My lord, their only objection is they want additional issues and the prior be sought in the written statement. I am withdrawing that prior in the written statement. That's all.
ಎಲ್ಲಿದು ಓದಿದ್ ಏನು ಅಂತ ಹೇಳಿ.
They are sought for additional issues at page number 56. May kindly peruse, my lord. This is what the honorable court has made observation on last occasion.
Page number 56.
56 prior B. Restrain the plaintiff and defendant 1, 2, 3 and defendant for 5 to 10 not to put up any construction or encumber upon suit scheduled properties in any manner till the final disposal of a case by granting relief of permanent injunction. In view of this prior, this honorable court has come to conclusion that additional issues needs to be framed. Subsequently, my lord, this honorable court has advised me to withdraw that prior. Hence, I have filed a memo to withdraw that prior.
Where's that issue? Tell me. In para 40.
They are interested in the net of settlement of the group. Go well and highly interested. Also, not for compliance. He made a prayer against the dependent of the and they can so, the next one, and as
Fourth defendant has also filed a counterclaim. The suit is filed for partition.
Partition. It's not our share in the counterclaim.
I thought, Sidramaya, even if you withdraw this plaint government or plaint prayer,
Yes, please.
prayer by the defendant number 4 remains. So
Remains
that
with
is-
respect to their shares, my lord.
That issue will have to be framed insofar as fourth defendant is concerned. Whether suit filed by plaintiff and fourth defendant is maintainable without seeking relief of declaration in respect of registered instruments. Whether the counterclaim made by the fourth defendant against the four defendants is maintainable in law. Why is it not maintainable?
They have said, under the brain to us, there is a way. Partition and separate. They are not further and trying to take this. They are sort of they are almost
Obviously.
It's time to make it independent, work in the different mind thing, not to put up any concern. Taking that current government to make the payment, that is not another issue.
Yes, Mr. Sidramaya, even if you withdraw this counterclaim.
My lord, the plaintiff has not, the defendants have filed a counterclaim. Plaintiffs have not sought for any relief for paying of additional issues. Only the co-defendants, they are claiming to frame the additional issues.
Correct.
We have sought relief against the plaintiff, my lord. We have not sought relief against the defendants.
But you look at the tenor of your relief sought for.
for partition and separate portion of deceased AR Iftikhar Ahmad, 1/3 share in the entire A schedule properties and also is 2/12 share in the entire B schedule and C schedule properties. To be allotted in
Please come to the additional issue suggested. One is whether the counterclaim made by the fourth defendant against the four defendants is maintainable in law. It's a question in law.
Yes.
That can be framed. You have to prove that it is maintainable. Rules applicable to a plaint are applicable to a counterclaim. So therefore, this issue will not arise actually.
Yes.
Since
Yes,
it is
yes.
raised a question of law, let that be framed. Whether court fee paid by the plaintiff and fourth defendant is sufficient. What is wrong in that?
That issues framed by the trial court may kindly peruse, not produced.
Produce ಮಾಡಿದಿರಲ್ಲ. Page number 80.
80. No, yes, 82. My lord, additional issues may kindly peruse, my lord. Already additional issues were framed by the trial court. Whether the fourth defendant proves that she is the wife of late AR Iftikhar Ahmad. Whether the fourth defendant proves that D11 and D12 are sons of late Iftikhar Ahmad and me. Whether defendant number 4, 11 and 12 were entitled for 1/3 share in A schedule property and 1/3 share in B schedule property.
Based on your counterclaim.
Yes, this is the based on our counterclaim.
Now counterclaim reply file ಮಾಡಿರೋದು ಯಾರು? Who has filed the reply to the counterclaim?
My lord, reply is filed by the defendant number 3.
ಏನಂತ ಹೇಳ್ತಾರೆ?
They have filed an IA for framing of additional issues. But this writ petition is filed by
reply of the defendants ಏನಂತ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ?
ಇಲ್ಲ
What
ಅದು
do they say? Do they say that the counterclaim is not maintainable against them?
ಇಲ್ಲ ಅದು
Yes, what do you say? Page 77. Yes, what have you said? Cannot be made in such a counterclaim against is not maintainable in law. Court fees ಬಗ್ಗೆ ಎಲ್ಲಿ ಹೇಳಿದಿರಾ? Para? Not the owner. 35(2). Then what is the other issue? Yes, Mr. Sidramaya.
Yes, please. That's all the.
So let all these issues will arise.
Yes.
ಅಷ್ಟೇ ಅಲ್ಲ?
Yes. My lord, since it's a suit for partition, my lord, time frame kindly fixed for disposal. My lord, one or the other applications were filed.
Suit ಎಷ್ಟನೇ ಇದು?
2018.
ಬರುತ್ತೆ ಬೆಂಗಳೂರಲ್ಲ?
ಇಲ್ಲ, ದಾವಣಗೆರೆ.
Liquidation is allowed. Consequently, the impugned order rejecting IA filed by the defendant 1 to 3 is set aside. Consequently, IA number 5 is allowed, and the issues suggested in IA number 5 shall be framed as additional issues in the suit. ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
At the stage of defendant evidence. Defendant's evidence.
Since the suit is filed in the year 2018, the trial court is directed to dispose of the suit within a period of 1 year from the date of receipt of a certified copy of the order.
Yes, please.
Yes, all other cases. ಯಾವ್ದು date ಕೊಡಿ ಎಲ್ಲ.
59.
Please take a date from the court office.
My lord, serial number 49, my lord.
49 years. There who appears? Yes, Mr. Cyril. will permit them to lead further evidence. No. The admission of the signatures on the affidavit, which they have admitted. Them to backtrack or rescind. No. See now, for example, she might even today she might say that such a bill is not executed. Even now she can say, you can disprove it by saying that no, you have appeared before the court in Bombay. You have signed an affidavit. So whatever admissions that she has given in the course of cross-examination, we will not permit them to lead further evidence on those aspects. ನಾಳೆಗೆ ಹಾಕ್ರಿ 2014 matter.
62 matter. 62 matter. Next matter.
ಜಾಸ್ತಿ ಕೋರ್ಟ್
Interim order is there.
ಎಲ್ಲ interim order extend ಆಗುತ್ತೆ.
My lord, in serial number 75, my lord, matter is posted tomorrow for argument before the trial court. It is a last matter, my lord, summoning of the document. Yes, please. Serial number 75, my lord. This is with respect to summoning of the document from the LRF records. My lord, the plaintiff's contention, the respondent's contention is that the ancestors of the petitioners have given a consent for the disposal of the LRF proceedings. We have disputed the signature, my lord. We want summoning of those signatures, original signature from the office of the Tahsildar.
All these matters will be listed.
Tomorrow matter is posted for argument, my lord.
ಎಲ್ಲಾ ಕೇಸಲ್ಲೂ ಹಂಗೆ ಇರುತ್ತೆ, ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ಆಯ್ತು, they will stay the proceedings till the next day and then stay ಮಾಡೋಣ ಅಂದೆ. ಇಲ್ಲ, ನೀವಾದ್ರೂ ಸ್ಟೇ ಟೈಮ್ ತೊಗೊಳಕ್ಕೆ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಹೇಳಿ, ನಾನು will stay the date. ಯಾವ್ದದು? ಏನಂತ ಇದು? ವಾಟ್ ಇಸ್ ದ ಕೇಸ್? ಇದ್ರದ್ದು ಥಿಯೇಟರ್, 3 ವರ್ಷ ಥಿಯೇಟರ್. ಯಾವತ್ತು? ಇಲ್ಲ, ಅದು ಎಷ್ಟು ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. On the last date, the senior counsel 75,000 ಅಡಿಗೆ ಅಲ್ರಿ, 75,000ಗೆ ಅಡಿಗೆ 75,000 45,000 2 ಲಕ್ಷ, 5 ರೂಪಾಯಿ ಆಯ್ತು ಅಡಿಗೆ. 3 ವರ್ಷ ಥಿಯೇಟರ್ 5 ರೂಪಾಯಿ ಬಾಡಿಗೆ ಎಲ್ಲ ಕೊಡ್ತಾರೆ. Be reasonable, otherwise we'll dispose of this suit with the application. Be reasonable. Come, ಹೋದ್ಸತಿ 75,000 ಬಂದು 75,000 2 ಲಕ್ಷಕ್ಕೆ ಬಂದಿದ್ದೀರಾ. ಈಗ 2 ಲಕ್ಷಕ್ಕೆ ಬಂದು 3 ರಿಂದ 5 ರೂಪಾಯಿ ಬಂದಿದ್ದಾರೆ. ಎಷ್ಟು ಹೇಳಿ? 50 ರೂಪಾಯಿ ಕಡಿಮೆ ಇಲ್ಲ. 50 ರೂಪಾಯಿ ಕಡಿಮೆ ಇಲ್ಲ. These are all very new matters. 2022. Only have a date. Court officer will give all the dates. The court of, please ask the court of. The court officer, depending upon the treasurer, he will give the date. ಮುಗಿಸ್ಕೊಳ್ಳಿ ಸರ್. ಹುಡ್ಕೊಂಡೆ ಬರ್ಲಿಲ್ಲ ಶಿವರಾಮ್ ಅವ್ರು ನಾಳೆ
Court officer serial number 70. Court officer serial number 70.
ಅದಕ್ಕೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ನಮ್ಮ ವಿಡಿಯೋದಲ್ಲಿ ಇರೋರ್ಗೆ ಕೇಳ್ತಾ ಇಲ್ಲ.
Court officer ನೋಡ್ತಿರಂಗೆ
ಸರ್ ಹೇಳಿ ಸರ್ ಹೇಳಿ ಸರ್.
serial number 70 ಹೌದು.
ಯಾವತ್ ಬೇಕು ಸರ್?
ಮುಂದಿನ ವಾರ
14th ಮೇಲೆ ಕೇಳಿ ಸರ್.
ಹಾಕಿ 14th ಹಾಕಿ 15th ಹಾಕಿ.
ಆಯ್ತು ಸರ್ 14th ಸರ್.
ಓಕೆ
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 73 23 ಐಒ ಇದೆ ಸರ್, ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು.
ಆಯ್ತು ಸರ್ ಇದ್ರೆ ಆಗುತ್ತೆ ಸರ್.
ಸರಿ, ಥ್ಯಾಂಕ್ ಯು.
ನೆಕ್ಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್
71 ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 71
ಯಾವತ್ತು ಸರ್? 14th ಮೇಲೆ ಯಾವತ್ತು ಕೇಳಿ ಸರ್.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 73
ವಾರ ಒಬ್ರು
73 22nd ಆಗುತ್ತಾ? 23rd ಅಂದ್ರೆ ತಾವು?
ಸರ್ 23rd ಸರ್ ಖಾಲಿ ಇರೋದು.
22nd ಆಗುತ್ತಾ ಅಂತ?
ಇಲ್ಲ 23/9.
ಹಾ ಸರಿ ಆಯ್ತು.
23/9.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 71 12 ಹಾಕೊಳ್ಳಿ ಸರ್.
71 10th ಗಾ?
12th ಸರ್.
14th.
ಸರ್ ಅಲ್ಲ 13th ಆಲ್ರೆಡಿ ಅಲ್ಲ ಇವತ್ತು ಇದ್ದು 13th ಹಾಕ್ತಿದ್ದೀನಿ ಇವಾಗ ತಿರ್ಗಾ ಟ್ರಯಲ್ ಕೊಟ್ಟಲ್ಲಿ.
ಸರ್ ಯಾವತ್ ಬೇಕು ಹೇಳಿ ಸರ್.
12th ಹಾಕೊಳ್ಳಿ ಸರ್.
ಆಯ್ತು 71
ಹೌದು ಸರ್.
71 12. ಓಕೆ ಸರ್. ಮೇಡಮ್ ಹೇಳಿ. ಮೇಡಮ್ ಹೇಳಿ.
ಇದು 59 ಸರ್.
59 ಯಾವತ್ ಮೇಡಮ್? ಯಾವತ್ ಬೇಕು ಹೇಳಿ ಮೇಡಮ್.
15
59
ನಾಳೆ ಹಾಕಿ.
ನಾಳೆ ಆಗಲ್ಲ. 14th ಮೇಲೆ ಯಾವತ್ತಾರು ಕೇಳಿ.
20 ಸರ್.
20 ಇಲ್ಲ 23.
ಸರಿ ಸರ್. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ ಸರ್.
ಇರ್ಲಿ ಆಯ್ತು ಮೇಡಮ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 65.
65. ಅದೇ ಇರ್ಲಿ ಮೇಡಮ್. 65.
ನಾವು ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ
ಯಾವತ್ತು
ಡೇಟ್ ಕೊಟ್ಟಿದಾರ? ಯಾವಾಗಾದ್ರೂ ಆಯ್ತು.
65 23rd ಗೆ.
23rd. ಓಕೆ.